has been postponed due to the financial crisis. That
other side, who's the other side?
JUV and Sachin sir.
Okay. From supplementary list for first hearing item 1 BA 6597 of 2026.
Where is the petitioner? Petitioner absent, just for next Tuesday.
Item 2 BA 6670 of 2026.
Under section 103, not named in a form name transfer on the basis of named activity within the category and page number 22 and from proposal of season list, it appears that the weapon has been recovered on the stance of the said Govinda Kharia, page number 16. गोविंदा खारिया के निशानदेही पर फिर पेज नंबर 17 में है लगा टारगेट जिसे लंबाई लगभग 2 फीट है और पेज 20 पे भी है गुलाबी और सफेद रंग का पूरा गमछा लगा हुआ आसमानी रंग का टी-शर्ट लगा हुआ ये गोविंदा खारिया का स्टांस पे रिकवरी है बाद में हम सरेंडर किए
इनका नाम कन्फेशनल स्टेटमेंट
उसी के कन्फेशन पे सेव एंड एक्सेप्ट कन्फेशन देयर इज नो एविडेंस अगेंस्ट दिस चार्जशीट हैज बीन सबमिटेड
Charging
चार्जशीट
for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the arms have been recovered on the basis of the confession statement of the accused Govinda Kharia. And the name of the petitioner transpires in the confession statement of the accused. Govinda Kharia has been enlarged on bail by the government bench in BA number 5763 of 2026 by order dated 25/6/2026. The charge sheet has already been submitted. The learned counsel for the state has opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner is not in dispute. Charge sheet कब हुआ?
चार्जशीट हुआ 22/5/2026
Submitted on 22/5/2026. After hearing the learned counsel for the parties, and it appears that the name of the petitioner has transpired in the confession statement of the accused, namely Govinda Kharia, who has been enlarged on bail. Any antecedent?
no antecedent. Paragraph 14 antecedent.
And in paragraph 14 of the bail application, it has been stated that the petitioner has no criminal antecedent. The petitioner is directed to be released on bail. On following conditions, the court shall call for the antecedent report of the petitioner from the state. If any antecedent is found, the petitioner shall not be released.
From trade list for order certified item 1 BA file number 16074 of 2026.
Now, I have tried for ignoring the three defects.
What all defects are there?
What is the name mistaken identity man?
Mistaken identity.
Page number 60 in P order. I filed this MCA application in the name of Deepak Mahato alias Deepak Mahato, not in the name of Deepak Bulbulia Deepak Mahato. And the lower court, session court has written this name.
be that this is the name which is transpiring in the
No.
case record.
Original accused is Deepak Bulbulia. And in view of the protection warrant issued in 2025, and this petitioner, Deepak Mahato, was remanded from Saibasa jail.
By saying
Both
that
are
he is-
kind of different.
What is the father's name of Deepak Bulbulia?
My lord, page number 37. Charge sheet. It is Vikas Pasi. Page number 37.
And what is this bail order of Deepak Mehta?
He was granted bail by Honorable High Court. That is page number 38.
In which case?
In this case, one,
So what happened?
I am not Manoj Bulbulia, I am not Deepak Bulbulia. I am Deepak Mahato.
No, page number 44 is what? Page 44 is what?
It is another case in Chaibasa.
So
Page
now
number
take
30.
Rambala. And what is the father's name of Deepak Bulbulia?
Vikas Pasi, page number 37. Charge sheet.
Page number 37.
7.
37 में क्या है?
Charge sheet है हमारा.
Charge sheet तो नहीं है. 37. मनोज बुलबुलिया alias Deepak Bulbulia.
Father's name is Vikas Pasi. I have connected all the identity of Aadhaar card, DL, passbook of the bank. That is Deepak Mahato. Father's name Ram Balak Mahato. Page 46, 47, 48, 49.
तो 2010 का बिल का तो रिकॉर्ड नहीं बना. ऑनलाइन भी नहीं होगा क्योंकि मनोज बुलबुलिया alias Deepak Bulbulia को बेल हुआ इसमें. We have annexed.
Annexed 38.
And then मुझे उनके पिताजी का नाम नहीं पता चला. स्टेट है इसका काम तो फाइल कर रहा है. There is a mismatching name. IA number 10107 of 2026 in BA filing number 16074 of 2026. The learned counsel for the petition submits that Deepak Bulbulia and Deepak Mehta are completely two different persons. And therefore the defect pointed out by the office being ignored. The records of the case also reveals that Manoj Bulbulia alias Deepak Bulbulia was enlarged on bail by this court in BA number 3386 of 2010 by the order dated 22/9/2010. And the same case was in connection with Jainpur, yes, case number 102 of 2009, corresponding to GR number 901 of 2009. Council for the state is directed to seek instructions and file a counter affidavit to the individual client. वो इसलिए दे दी है आपको उससे पिताजी का नाम नहीं पता।
मैं चाची पे लिखा हो बेला दिया नाम उसका।
कोई बात नहीं। उस बेल ऑर्डर में भी तो होगा ना, उस केस में होगा ना, जैनपुर वाला केस में।
हाँ, मैं एक और मैं बताना चाह रहा हूँ कि ये दीपक गुरुग्राम यूजेस इज सम इंफॉर्मेशन बट बाय क्लाइंट राइट्स टू द सिग्नेचर।
एलिगेशंस भी काफी सीरियस है, इसलिए पता करना जरूरी है। उसमें जिस जो बाप का नाम होगा ना 2010 वाले केस, उसी को हम माने। दीपक गुलगुलिया, मनोज गुलगुलिया, दीपक मेहतो, कई सारे नाम हैं। आप post this case on 18th, the counter affidavit be filed by court. और ये वाला जो जैनपुर केस का डिटेल नहीं है, इसमें नेट में भी देखेंगे तो डिस्पोजल में तो मिल जाएगा, जो भी जजमेंट हुआ होगा डिस्पोजल हो गया होगा वो केस। नहीं आई पूछ रही हूँ, तो पेंडिंग डिफेक्ट्स।
For first filing item 2, BA 6673 of 2026.
It is there, madam.
15 साल की।
हाँ 15 साल।
Council for the state is directed to serve notice. चार्जशीट हो गया?
यही बात पूछ रही है, कौन किया था पूछे थे कि ठीक है सर।
Council for the state is directed to serve notice upon the informant of the case. The council for the petition has submitted that charge sheet has already been filed. Date the case diary along with the statement of the victim recorded under section 183 ANSS be called for from the concerned court. आपके घर में लड़की रह रही है?
नहीं, उसी दिन रिकवरी हुई, वो अपने बोले कि हम नहीं जाएंगे।
लिखा है इसमें कि आप ही के घर में रह रही
है? नहीं, उसी दिन वहीं पर चली, मेरे घर चली गई, बोली लड़की ने स्टेटमेंट है कि हम जो है इसकी शादी करेंगे, महीने का हम नहीं जाएंगे बाद में। वो डायरी से आप देख लो।
along with the medical examination report of the victim. Post this case on 11, the counter affidavit will be filed by 7.
Okay.
Item 3, BA 6674 of 2026.
Also case of the secret 87. I am not the copy of the statement of the victim that will require.
Delhi क्यों चले गए?
मतलब?
Delhi, she went to Delhi.
हाँ, she went to Delhi as per the statement.
Yes.
हाँ, but her statement I have not the copy of her
You
statement.
don't have it is mentioned in the impugn order itself. You must be knowing. Did she went to Delhi? She was recovered from Delhi. CWC Delhi camp was.
But it appears that she went Delhi with the petition out of her suite with.
What is the age of the victim?
Look at the age of the victim here is 17 years. So that is the first one.
नहीं investigation अभी चली है.
नहीं investigation 29-26 हो गया.
दिल्ली लेके कैसे चले गया? ये हमें 6674.
उसको ये स्टेटमेंट देख लिया था. उसके स्टेटमेंट उसको मैं ये
गलत लिखा है इसमें. इसमें गलत लिखा है.
नहीं हम कुछ नहीं करेंगे.
She was recovered from CWC Delhi camp and handed over to Saharganj police station.
But whatever she stated that she was
खुद चले गई. उसके साथ चली गई, साथ गई ना।
हाँ साथ गई।
नहीं, आगे
अगर
नहीं गई।
फॉर द मोमेंट अगर मान भी लेते कि साथ गई है और ये भी लड़का 19 साल का लड़का है और 17 साल की लड़की है, देयर मस्ट बी सम एलिमेंट ऑफ लव रिलेशनशिप बिटवीन देम।
जैसे दिल्ली जाने वाला कहानी नहीं सुनी।
देयर मस्ट बी सम, अब कहीं को वो हल्ला या कोई आपका रेस्क्यू के लिए रेस नहीं कर रही है, तो
And she
स्टेटमेंट
was
में भी
also
गिवन,
sexually assaulted.
तो हर स्टेटमेंट में भी गिवन इज सी नॉट इन हर स्टेटमेंट में भी
जबरदस्ती वाला कोई ऐसे ये इसमें गलत लिखा है तो बोलिए हम मंगाते हैं। आपका यही सबमिशन लिखा यहाँ पे जो लिखा है इम्प्यून ऑर्डर में गलत। आप पैरविकार है ना, पता होना चाहिए आपको इम्प्यून ऑर्डर में क्या क्या लिखा है। चार्जशीट कौन सेक्शन में जमा हुआ वो आपको कुछ नहीं पता। चार्जशीट हो गया है, एज पर द इम्प्यून ऑर्डर इट इज अंडर इन्वेस्टिगेशन।
आज तो इम्प्यून ऑर्डर का इन्वेस्टिगेशन जस्ट अभी हम इंस्ट्रक्शन दी तो इंस्ट्रक्शन होगा कि चार्जशीट has been submitted.
For the learned counsel's opinion on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 29/4/2026 and charge sheet has already been submitted.
Yeah, Doctor, extremely sorry, interrupting. My learned friend having the copy of the case diary. 27/6/26 को चार्जशीट हुआ है, तो बताना चाहिए उनके पास है।
किस सेक्शन में?
हाँ बताते हैं, तो चार्जशीट हुआ है 87, 64, 196 एवं 4
And 4 box one.
है, जो है वो तो है उसको तो
Charge sheet has been submitted under section 87, 64,
64, 196 DNS
196 DNS and section 4 of the box
of
on 27/6/2026. The learned counsel for the state has opposed a prayer for bail and has submitted that as per the review order itself. The victim girl was taken to Delhi by the accused and was recovered by CWC Delhi camp and handed over to Jharkhand police station. And she was allured and abducted by the accused as per a statement under section 180 basis and she was also sexually assaulted.
17 साल 3
In view of the
महीना 15 दिन उसका एज।
the learned counsel submits that the victim was 17 years, 3 months.
हाँ 3 months and 15 days।
In view of the aforesaid allegation against the petitioner and that the victim was taken to Delhi and recovered from Delhi, this court is not inclined to allow the petitioner on bail.
I'm sorry to say, my lord, sometimes some difficulty with us. Though the case diary was in the state, everything was there. He should assist to report lottery का case diary है चाची। कभी-कभी हम लोग को instruction तो
आप क्यों नहीं बताते?
बता, तो जब था इनके पास तो बताना चाहिए पोक्सो में, ठीक है पोक्सो में हो गया, तो आपको कोई बेल से होना चाहिए, एटलीस्ट ही शुड असिस्ट दी कोर्ट।
हाँ, आप क्यों नहीं बताते? Silence is not approved in this court.
हो सकता है कुछ फैक्ट हमारे पास नहीं हो सकता है।
Item 4, DA6675 of 2026.
This is an application for grant of regular way to the police under section 10 is modification and from the position of PO, one mobile has been recovered, which belongs from Sonu Chaudhary. There is no eyewitness here, and Sonu Chaudhary has been granted the annexure 2 million, running date 26.
ये दूसरा कोर्ट में कैसे भेजना?
कैसे भेजें?
दूसरे कोर्ट में बिल कैसे करना?
हुजूर आप
सोनू
वो
चौधरी
का
का,
हुजूर
राकेश बिंद का
हुजूर
25/6 का है, बहुत रिसेंट है।
जी
उस वक्त तो यही पेज चल रहा था।
सोनू चौधरी का
सोनू चौधरी का तो हम दिए
हुजूर जी
और उसके बाद ये राकेश बिंद का
मेरे पास तो
है, बीए नंबर 5802 और 26 इम्पोर्टेंट पेंशन हुआ है। दिखाइए। ये किनके क्लाइंट है, उनका केस सबसे पहले कॉल करिए, एडवोकेट को बुलाइए। वो आधार कुछ भी रहा हो, लेकिन जब एक बेंच असाइन है तो दूसरे कोर्ट में लगता है तो स्टेट भी कुछ बोलते नहीं, कैसे लगता है? आप लोग का काम नहीं है बोलने का। उनका केस नंबर पता करिए, वकील का नाम पता करिए और वकील साहब को बुलाइए। And tell her that there is a crash also over here. बताइए किसको, आप कौन हैं? Who are you?
हम छोटे लाल husband.
Husband.
Three witnesses have been examined. I including informant. I have annexed the position running this 24. This has come with para one. छोटे लाल दिन घर पर नहीं था। His custody since 18-10-25, having no criminal history. No history. I have mentioned in para 15.
आप हस्बैंड है, आपकी वाइफ घर के अंदर सो रही थी, आप बाहर सो रहे थे, and she was found dead.
गवाही में आया हुआ इन्फॉर्मेंट जो है कहा है कि छोटे लाल दिन घर पर नहीं था। सौरभ चौधरी सब आए।
FIR नहीं है। कौन है?
निवेदन पूर्वक करना कि मैं चंदन का स्वयं जिला गढ़वा निवासी श्रीमान को सूचित करते हुए हालांकि मुझे ग्रामीणों के द्वारा जानकारी दिया गया कि दिनांक 13-10-25 पर रात्रि को 8:30 बजे मुझे बंस सुष्मिता देवी 29 वर्ष खाना खाने के बाद घर के सोने चली गई थी और उसका पति छोटे लाल भी मेरी बात जो इन्फॉर्मेंट है वो भी कह रहे कि घर पर हम नहीं थे, वही खाना खाने के बाद घर के अंदर सोने चली गई थी एवं उसका पति छोटे लाल दिन मेरी बहन के द्वारा मना करने के बावजूद घर के बाहर सोने की बात बताकर घर के बाहर सोया था, किंतु लगभग 10:30 बजे मेरी बहन का पति छोटे लाल दिन ग्रामीणों को हल्ला करके बताया कि मेरी पत्नी किसी के द्वारा हत्या कर दिया गया है। इसके पश्चात अन्य ग्रामीण घटनास्थल प्राथमिक मध्य विद्यालय के
आया है का लड़ाई झगड़ा अपनी वाइफ के साथ कुछ हो रहा है। Learned counsel for the state is directed to file a counter affidavit in this case. Get the case diary along with the postmortem report of the victim, of the deceased. We call for condolence. Post on 18th August. The counter affidavit we filed by 14.
Item 5 PA 28.07.2026.
Case was registered under section 96 of BS and section 8 of the Plan of Poxo.
Read the FIR. FIR कभी?
Yes. Case 15. निवासी हूँ सच हूँ, मेरी बेटी सच है, वो अपनी सहेली सुदेव
14 वर्ष
जी, परंतु मेरी बेटी 10 बजे वापस नहीं, नीतू कुमारी घर जाकर पूछताछ की, नीतू कुमार मेरे 5 बजे अपने घर जाने निकल गई। बड़ी पूरी गांव खोजने दिए तो पता चला कि पवन कुमार दास पिटिशनर मेरे नाम को 14 वर्ष को गलत मीन से भगा कर ले गया। वहीं पे गए और रेलवे स्टेशन से
रिकवर कहाँ से हुई?
रेलवे स्टेशन
पिटिशनर के साथ
statement मंगा के देख लिया 164, there is no 183 statement, there is no such medical report is also, now the charge is also this.
Got married in the temple. She was taken by the accused to his house of his sister where she physical relationship is also established.
But 164 statement में
यही तो लिखा है कि यही बोली है वो आपने statement.
183 my submission is what she has stated. We kindly be seen whether any physical relations will be referred to she is stated or not. Or marriage, because in our statement of what happened 181 statement, I don't find any such statement. Therefore, I claim 188.
Where is the statement on the 180? 180. 180 का statement कहाँ है आप बोलते हैं? आपके पास आप देखें ना कि नहीं ऐसा कुछ नहीं बोली.
I have been informed. I don't have it. Newspaper has not been given to me. But 183 statement may be seen. There is no proof.
Although there is direct allegation against the petitioner in the statement as per the interim order, wherein the victim has supported the allegation that she had gone with the accused and both of them got married and she was taken by the accused to the house of his sister where physical relationship was also established between them. However, the counsel for the petitioner submits that the statement of the victim recorded under section 183 BNSS perused. Office is directed to call for the statement of the victim recorded under section 183 BNSS from the concerned court. Post this case on 5th of August. In the supplementary process.
Item 6, DT.28.07.2026. of 2026.
Direct allegation क्या है?
सप्लीमेंट्री देखिएगा जो डिपोजिशन का
इनका
victim का खुद कह रहे हैं कि हमें को फोन करके बोला कि मेरे साथ कुछ गलत नहीं हुआ है क्योंकि उससे मिलना हमारी माँ को पसंद नहीं था इसलिए केस किया हम.
Victim 14 years की.
Just a moment.
Plate number 30.
कुछ allegation नहीं लगा. 183 is statement. You are for the informant? You have seen the statement of the victim? मुझे दिखाइए.
नहीं हम देख चुके हैं उसको. नॉट सिर्फ इसमें जो FIR है उसको एक बार देखिए.
FIR क्या देखी?
She is the 14 years old.
She is 14 years old. उसको बुलाया, बात कर लिया, उससे प्यार कर
नहीं
लिया तो क्या? आप 183 का statement देखिए.
हाँ ठीक है 183 में बोलिए.
हाँ देखो 183
देख
देख चुके ना?
वर्ष में क्यों फादर के इससे चलते हम फाइल किए थे. मैं अपनी मर्जी से उस लड़के से मिलने गया.
और कुछ नहीं.
यस का
मैं प्यार करती हूँ. कस्टडी कब से? और the learned counsel appearing on behalf देख लिया ना? 183 का statement देख लिया. और the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is 20 years, is in custody since 14/3/2026 and charge sheet has already been submitted. He has referred to the statement of the victim recorded under section 183 BNSS, wherein she has stated that she went to meet the petitioner on 13/3/2026 at 12 noon. And when her mother came to know about it, she did not like it. And she has also stated that she loves the petitioner and the petitioner did not do anything. The learned counsel for the opposite parties have opposed a prayer for bail by submitting that the victim is just 14 years of age. After hearing the learning counsel for the parties and after going through the statement of the victim recorded under section 183 BLSS.
What's the pattern of medical report? As per the medical report, the para 50F thereof it has been opined there is a venial position upon the victim.
Medical.
If you not the page number 15, last one. The detailed medical examination report of the victim dated 13th March 26 corroborates the allegation of rape upon her.
Date the case diary along with the medical examination report of the victim who called from the center. I will do this diary. Hold this case on 11th. The state file contract.
11th August.
11th August. The contract will be filed by 7th. You are for the informant, counsel for the informant is present. वो तो तुरंत ही आ जाए ऑर्डर कम्युनिकेट होगा तुरंत आ जाए
Item 7, DA 688 of 2026.
Your office under section 64 BNS 89 of Tourism. After investigation, charge sheet has been submitted under section 64 to MFBNSP.
You are for the informant. What is the stage of the case? What is the stage of the case? You are, he's for the petitioner or he's for the informant? Mr. Modi, you are for the informant? Yes, tell me.
Stage from the tracking of charge came
क्या बोल रहा है?
Lord, from the usual of the FIR, there is no mentioning of date of the offense when the offense took place. And kindly have to annexure to Lord, there was an agreement between the brother of the victim and this petitioner regarding money. And when the petitioner asked his money back, he did not return and falsely implicated in this case.
Video has been recovered. What is the stage of the case?
Case diary आया नहीं case.
Stage क्या है? आपको नहीं पता? आप बताइए. Charge sheet has been submitted.
Submitted.
No video has been recovered or video has been recovered?
No video has been recovered.
And what about the statement of the victim under section 183? तो उनका statement तो देखेंगे ना? You have a copy of the statement? I can't hear you. What do you mean? You did not hand it over to the police? So you are remediless also. The police. I do not know from where do I get this. Police has not recovered it from you. You can send through? To whom? Very good. वीडियो अपने पास रखिए और उसी को सर्कुलेट कराइए. IU has not recovered it. What do you mean? You are the informant of the case and the IU you say has not taken it from you.
IU was changed. Subsequent IU even requested to take us to the did not accept it.
You requested it him in writing?
Yes, Lord. No, not in writing. But
Then,
the villagers have requested, but he did not accept it. But it's a basic case, but where it's
आपका parallel investigation तो कोर्ट में नहीं चलेगा ना? पैरेलल इन्वेस्टिगेशन कोर्ट में नहीं
Yes,
चले.
yes, but I have asked my client to approach the SP and other officers and to report also.
That's
For report also in this regard.
I'm mentioning para 14 that video clip has not been found during investigation.
And whenever my marriage is going to some another cause, this petitioner always interferes with my marriage of marriage and makes the videos and photos viral.
And even date of offense has
The
not
learned counsel for the petitioner has submitted that the charge sheet has been submitted and no video was recovered. To this, the learned counsel for the informant has submitted that the investigating officer of the case, in spite of repeated requests by the informant, did not take the video and the photograph, which is available with the informant. The learned counsel for the state is directed to file a counter affidavit in this connection and specifically state as to whether the video and photograph has been recovered during investigation. ये सब बहुत गलत बात है, इस तरह का एलिगेशन नहीं आना चाहिए.
maybe wife को भी
In the meantime, the informant shall also file counter affidavit. Post this case on 18th. The counter affidavit be filed by 14th. Then counter affidavit be filed by 10th of August. Let the statement of the victim recorded under section 183 BLSS be forthcoming from the concerned court along with the case diary and its enclosures.
Okay.
You file your affidavit at the earliest, and serve it upon the state also.
Item 8, BA 6689 of 2026.
Yes, matter related to murder of the
Yes.
this case lordship as per the release.
Case is of 2014.
Yes, sir.
Where were you?
2024.
कहाँ थे आपका तो सब सारा प्रोसेस एग्जॉस्ट हो गया.
उसके बाद स्प्लिट अप हुआ चार्ज फ्रेम. वो एक ट्वीट का भी मतलब सिमिलर जो बिल हुआ उसमें भी लगभग यही था.
लगभग यही था मतलब.
तो सिमिलर फुटिंग का केस है.
सिमिलर फुटिंग किसको बोलते हैं?
सिमिलर फुटिंग जैसे ऑन मेरिट एंड आल्सो लॉट्स टेक्निकल की वो एब्सपेंडर थे वो भी उनका बिल ग्रांट हुआ है.
और स्प्लिटर ट्रायल में क्या हुआ?
चार्ज फ्रेम हो गया उसमें. और ओरिजिनल केस में भी चार्ज फ्रेम हुआ है विटनेस.
पढ़िए एफआईआर.
दूसरे के संबंध में कहना है कि मैं लादू बांग्ला सुरसो निवासी हूँ. मेरी माँ माकी बांग्ला पिता स्वर्गीय सुरसो की रात घर से ही लापता है. मैं मजदूरी करने प्रदेश गए हुए थे. इस घटना के संबंध में मुझे जानकारी नहीं थी. इस घटना की जानकारी मेरा भाई भूकम बांग्ला पिता स्वर्गीय साडो बांग्ला ने माँ को एक क्रियाक्रम में शामिल होने के लिए फोन द्वारा एक सप्ताह बाद खबर दी. तो हम लोग प्रदेश से आकर मेरा भाई तुरुतम बांद्रा को इस घटना के बारे में पूछा तो कुछ जानकारी नहीं थी. हम लोग बार बार पूछने पर भी कुछ नहीं बताया. हम लोग इधर उधर संबंध में भी खोजबीन किया, कहीं नहीं पता चला. मेरा बहन गोवई बांद्रा पिता स्वयं से इस घटना के बारे में बताया कि 4/9/2014 की रात हम लोग घर पर ही सोई हुई थी. 3 आदमियों ने घर का दरवाजा पैर से मारकर खोला और घुसा माँ को पकड़ कर ले गए. मुझे भी मुंह पर एक आदमी ने दबाया था. चिल्ला भी नहीं सकते और माँ को रात को ही कहीं ले गए. आदमियों को रात के समय पहचान नहीं आई. इस घटना के संबंध में मुझे एक संदेह कि बरसों पहले से मेरी माँ माकी बांग्ला निम्नलिखित
क्या बोलना है स्टेट?
एलिगेशन है मतलब उनके साथ
बरसों पहले बोले थे कि डायन, बरसों पहले, huge gap, and they have not been identified.
रात का समय था तो जाएंगे
Identified हुआ सबके साथ general allegation.
फोर्सफुली उसको मुंह दबा
नहीं नहीं वो ठीक है, लेकिन इन्होंने दबाया कि इन्होंने दबाया, कैसे पता चला?
इंडियन गार्डन में भी आया है मैडम
क्या है?
कि उसको अक्यूज पर्सन लोग ले गए हैं पढ़ा देता हूं पेज नंबर 29 में लिखते हैं स्टेटमेंट में दी स्टेटमेंट ऑफ द सिस्टर ऑफ द इन्फॉर्मेंट नीचे लिखते हैं कि को अक्यूज जितेंद्र वाद्रा took him to the school stating that the meat had been put there and that when he reached there he found the accused physician present there along with the other named accused person and dead body of the lady laying there and the accused physician describing
They were found disposing of the dead body.
murder.
By whom?
वो अक्यूज भी वहां पर है स्टेटमेंट में दी स्टेटमेंट ऑफ द सिस्टर ऑफ द इन्फॉर्मेंट
extrajudicial confession and the statement of the
पेज 29 में accused pending order
The learned counsel for the state is directed to file a contract affidavit. Contract affidavit filed करें. Let the case diary dash it हो गया.
Yes.
Let the case diary along with its enclosures be called for further consent. Post on 11th, the contract affidavit will be filed by 7th.
Item 9, DA.28.07.2026.
Based on the section 316, 318 and 319 BNS and 66C, 66D and 67 of the IT Act.
What is the stage of the case?
Because it's for police paper. Charge investigation.
Statute was submitted when?
Yes, ma'am.
When the statute submitted? The amount has been credited in your account.
Because in the diary notes, it is showing that 3-4 transactions have been there in my bank account. But from where those transactions have come, that is not being.
You have to explain.
Because that I will explain.
How much is the amount involved in your account?
Because that is 4,000, 500, and 150.
The learned counsel for the state is directed to file counter affidavit in this case along with the criminal antecedent report of the petition. आप कहाँ के रहने वाले?
Yes, I am a resident of Chatra district.
जो हम लोग का साइबर ऑफेंस वाला है वैसा ही. Let the case diary along with its enclosures be called for further consent. Post on 19th, the counter affidavit will be filed by 18th. Let us see what is there.
Yes.
Item 10, DA.26.97 of 2026.
The present case is registered under section 376.
So read it. Read that.
This page 13. सभी ने निवेदन पर रखा कि मैं सचिन सच जामताड़ा के रहने वाले मेरी शादी 2022 में बोटबेरिया के परिवार सारी पिता सचिन सच से संपन्न हुई थी। ससुराल में रहने के दौरान रिश्ते के देवर इसाक अंसारी पिता सचिन सर जामताड़ा मुझे अपने प्रेम जाल में फंसाकर मेरे साथ शारीरिक संबंध बनाने लगा तथा इस बात की जानकारी मेरे ससुराल वालों को देकर मेरे पति फहीम अंसारी से तलाक 2023 में करा दिया एवं तलाक के बाद शादी करने की बात करके मेरे साथ लगातार शारीरिक संबंध बनाता रहा, लेकिन 2025 तक इसाक अंसारी ने शादी नहीं किया तो मेरे घर वालों ने पुनः मेरी शादी करीम अंसारी पिता सचिन सर नाना सचिन सर देवघर में करा दिया, लेकिन इसाक अंसारी के द्वारा छाता पत्थर स्थित मेरे ससुराल में ही मेरे इसाक अंसारी के रिश्ते की बात बताकर वहां से मेरा तलाक करा दिया। इस बीच में जब भी मैं अपने मायके आती थी तो इसाक अंसारी मेरे साथ शारीरिक संबंध बनाता था।
आप इन्फॉर्मेंट क्या बोलना है आपको, क्या बोलना है? She is a married lady having relationship with others. कैसे हो?
But this was on the pretext of
How on the pretext of marriage? She was already married. How on the pretext of marriage? The first incident is of 2022. Custody कब से?
I'm in custody since 16/4/26. Charge sheet have already been submitted.
बोलिए कुछ तो बोलिए, क्या बोलेंगे?
And this is with the family member only. This was being committed, and in the case report it was
कोई
seen that
forceful नहीं है, कुछ नहीं है.
but he didn't.
प्यार का रिश्ता बना के समझ बना.
वापस इनसे किए नहीं, वो कहीं और.
कोई बात नहीं किए ना. शादीशुदा lady is having relationship. क्या कोई comment करेगा?
Of 7 months with him, with the petition.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that on the face of the FIR, the informant of the case was married and the petitioner developed love relationship with her and established physical relationship, which ultimately led to her divorce. Thereafter, also the petitioner did not marry her. She was then married to another person, and thereafter she was again divorced. दो बार divorce हुआ है ना? And the petitioner continued to establish physical relationship with her in the pretext of marriage, and that she was pregnant by 7 months. The learned counsel for the petitioner has submitted that even on the first incident, at the time of first incident, the victim was married. And as per the FIR, there was the petitioner and the victim developed love relationship with each other. The learned counsel for the state as well as the informant have opposed the prayer for bail and have submitted that the victim has been, that the physical relationship was established in the pretext of marriage. To this counsel for the petition submits that the petitioner has no antecedent, no criminal antecedent, and charge sheet has been submitted on 16.
I'm in custody since
Petitioner is in custody since 16/4/26, and charge sheet has
Charge
already
sheet
been
has already
submitted.
been submitted.
After hearing the learned counsel for the parties and considering the allegation on the face of the FIR, it appears that even at the time of initial relationship, the victim lady was already married. Considering the fact that charge sheet has already been submitted, the petition is directed to be charged on bail. इसका मैटर है आपका मैटर. Serial number 29 आपका केस है. That lady was there with a child. आपके client है. चलिए
Item-
उनको
item
उनका आपका
29.
केस कर लेते हैं.
बोला कुछ गलती हुआ
Item 29 DA 5030
नहीं नहीं वो बेचारी अब कितना देर तक बैठी रहेगी.
उसके हस्बैंड का
स्टेटस रिपोर्ट एक आया है. व्हाट इज द स्टेटस रिपोर्ट? Statement of the victim.
under 183.
वीडियो और ये व्हाट्सएप चैट सब रिकवर हुआ?
नहीं मतलब कुछ नहीं हुआ है. पैरा 28 you not me can see that was the only allegation against me कि हम उनकी भाभी को कुछ भेजे हैं. She herself decided कि हम डिलीट कर दी. नहीं है मेरे पास. पैरा 28 और admittedly long standing relationship है. दोनों पढ़े लिखे हैं. दोनों शादीशुदा हैं. And they continued their relationship. मेरे पास ये सारा व्हाट्सएप है which we did not file a WhatsApp for this call. कि वो दोनों के कंसेंट से जो भी रिलेशनशिप हुए हैं.
But what it is not consensual because some objectionable photographs were along with the victim petitioner, and which was shown to her, and even it was sent to her the sister-in-law of the victim, and on the basis of showing the same the way it has been, she has been
It is the allegation.
and it is the allegation, and on confession also he has handed over it has that
Recovered the photograph has been recovered.
and finally उन्होंने कुछ फोटो प्राइवेट छुपा कर सुरक्षित सेव रखा है. इसे मेरे पास बराबर स्क्रीन मोबाइल से भी दिखा सकता हूँ. मतलब उससे भी मिला है और मेरे पास मेरी जो
मिला है मतलब कोई रिकवरी हुआ है?
हाँ मोबाइल उसका
बताइए ना कहाँ पर?
कंफेशनल स्टेटमेंट
पैरा 28 has been recorded.
पहले 24 में उसका कंफेशनल स्टेटमेंट है और उसका जब्ती सूची थी. लास्ट पैराग्राफ सेव करके जैसे मेरे पास मोबाइल में उसी के मोबाइल में था और ये उसका स्क्रीन लाल रंग का रेडमी स्क्रीन टच मोबाइल उसी में वो है. और उसकी भाभी जो मेरी भाभी है मेरी जो गोतनी है उसके मोबाइल
Page 28 पैरा 28
पैरा 48.
पैरा 48 nothing, no photo and no video was produced.
No, no, no.
Only
इस
the-
काम के प्राथमिक अभियुक्त संतोष कुमार रवि के द्वारा अपनी रेडमी कंपनी की टच मोबाइल जो बिना सिम का वादिनी सह पीड़िता का आपत्तिजनक फोटो वीडियो सेव कर रखा गया था जो विधिवत जब्त कर जब्ती सूची बनाया गया और माननीय न्यायालय में प्रस्तुत
My case is that it has never been produced. It was allegation. I was
It is there. It has been recovered. Your phone has been recovered. That is the primary evidence.
Phone has been recovered. Now I was making para 28. What is the allegation against? Allegation against me that I demonstrated that photograph to Jharkhand. Bhavi has said nothing with me.
yes मेरे पास मिला था हमको अच्छा नहीं लगा तो डिलीट कर.
That may be some allegation. It is admitted case that both are married. Both continued the relationship. Both married. The relationship was continued for years together. Now you are saying when after the dispute, we have the photograph, we have the conversation, which we can demonstrate that there were relationships in childhood. Both are childhood friends. But she did not disclose the same. Some photo might be with the petitioner, but he never disclosed the same. Only at the time of allegation of ownership, everything has been alleged. Whether I demonstrated that photograph to anyone, if anyone has seen that,
She has said that the sister-in-law saw the photograph
and after that deleted.
naturally she deleted, she did not like it.
That's in this case, if there would be any evidence ownership to suggest that I sent the photograph and used the photograph for the victim or against the victim ownership, then definitely I would have done. And I remain in custody. Admittedly, it is a consensual relationship between the parties.
You are in custody since when?
I'm in custody since 21/4/2026. Both are government servants. ये भी गवर्नमेंट सर्वेंट है और दोनों के बीच में चाइल्डहुड से रिलेशन है। अगर ऐसा है तो फाइल कर देते हैं सप्लीमेंट्री दोनों के बीच में व्हाट्सएप चैट है।
On behalf of the parties, the learned counsel for the petitioner submits that the petitioner and the victim were known to each other for quite some time, and the petitioner has been falsely implicated in this case. He has further submitted that there was relationship between the petitioner and the victim since childhood, and both are working. Correct?
Yes, both are educated.
Both are educated
Educated
and they are
and
working.
and married. Both are married.
And both are married. The learned counsel for the informant as well as the state have opposed a prayer for bail. The counsel for the informant has submitted that the obscene video was circulated in as much as it was sent to the sister-in-law of the victim, but he has stated that considering the nature of video, he deleted it. The learned counsel also submits that the obscene video has been found in the mobile of the petitioner as well, which has been seized. And ultimately, the charge sheet has been submitted under section 64/N/77/352/351/3 BNS and 67/67 capital A of IT Act. The learned counsel has submitted that obscene video was prepared and on the pretext of, and the victim was blackmailed and was repeatedly raped. After hearing the learned counsel for the parties and upon going through the materials collected during investigation, including the fact that obscene video has been recovered in the mobile of the petitioner, and there is direct allegation of blackmail on the basis of such obscene video, due to which the victim was subjected to repeated rape by the petitioner. This court is not inclined to enlarge the petitioner on bail. And also the statement of the victim recorded under section 183. It is always at this stage.
Item 11, DA.28.07.2026.
Yes, petitioner.
And section 67
Informant is appeared.
No, let me first time.
Custody कब से है आपको? चार्जशीट हो गया?
हाँ चार्जशीट में दिया चार्जशीट पे उनके 21/7/2026
The council for the state is directed to serve notice upon the informant of the case and file a counter affidavit with particular reference to the fact as to whether any video/photograph has been recovered. Let the case diary along with its enclosures be called for to the concerned court along with the statement of the victim recorded under section 183 BSS. The counter affidavit be filed by August 11th, post on the 12th.
Item 12, BA 6702 of 2026.
Yes, petitioner. The trial is at advanced stage. Out of 9, 4 have already been examined, right?
Yes.
And this was on 29/5/26. How many more witnesses have been examined so far?
5 is
No. 9 out of 9, 4 was already examined by 29/5/26. Thereafter, no witness has been examined.
Yes.
We'll expedite your trial. There is direct allegation against.
इसमें contradiction नहीं है। एक तरफ ये बोलती है कि मेरा भाईना मेरे घर में रह रहा है और दूसरी तरफ भी allegation लगा है। Opinions भी same अथॉरिटी बोलती है कि मेरी बेटी में 4 साल है और विटनेस बोलती है 2 साल। मेडिकल रिपोर्ट में कहीं कुछ नहीं आया।
माइनर है ना?
हाँ माइनर। लेकिन ऐसे
4 साल है 10 साल है इससे कोई फर्क नहीं पड़ता।
ये घटना हुई है और इलेक्शन टू देखा जाए उसमें कुछ नहीं होगा।
घटना नहीं हुई है, आपका ट्रायल चल रहा है, एलिगेशन बहुत सीरियस एलिगेशन ही जब तक कन्विक्शन नहीं हो जाता तब तक एलिगेशन ही रहता है। आपका एफएसएल वगैरह सब आ चुका है ना, आपका ट्रायल एक्सपेक्ट एफएसएल रिपोर्ट आ गया है ना ऑलरेडी।
नेगेटिव और सोलाइव अपडेट कुछ नहीं है बट असली पूरा
केस 2024 का है। Counsel for the state is directed to produce a copy of the official report in sealed cover before this court. And also file a counter affidavit along with and serve notice upon the informant of the case. वो डायरेक्ट है, यानी एफएसएल रिपोर्ट में क्या है इससे
this property dispute लेकर भी जैसे घटना एक्शन एलिगेशन लगा है सीरियस एलिगेशन लगा है ऐसा कुछ कोई नहीं है इसका इसी क्या
just for the legal counsel's opinion on behalf of the parties, the counsel for the petitioner submits that the petitioner has positive defeated in this case primarily on account of land dispute. The learned counsel for the state has opposed a prayer for bail and has submitted that there is direct and specific allegation made in the FIR itself, and the victim is minor aged
4 years.
4 years as per the FIR. And also the radiological examination of the victim. He has also submitted that the trial is in progress, and out of as per the inquiry order dated 29/5/2026, out of 9 witnesses, 4 witnesses have already been examined.
कहीं भी वो dispute regarding property नहीं आया है।
After hearing the legal counsel for the parties and considering the direct allegation made against the petitioner. And the trial is in progress. This court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The state shall also make effort to ensure that the FSL report, if any, if not already submitted to the court concerned, be also forwarded. Let a copy of this order be sent to FSL Ranchi, and counsel for the state is directed to communicate this order to the SP of the concerned district and to the director.
Item 30, BS6708/2026.
The informant and petitioner had no relationship between each other. Allegation against the petitioner is that he has clicked some photograph and tried to spread it virally. There was love relation between both the parties. The matter has been compromised. The girl had appeared before the court below and she has said that she has. Apart from that, charge sheet was submitted, charge was read. She was examined also in which she has started stand. On 3rd July, she was examined as PW.
You have brought down record the examination. Victim का age कितना?
She was 19 years. Paragraph and is for Shudori Kushi. I have also raised a compromise petition before. They were neighbors and they had no relations. Actually, the petitioner wanted to marry her. So that's why.
Hostile है. Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petition says that, as per the allegation in the FIR, certain photographs/video, certain photos/video which were objectionable were made by him. Further submits that the petitioner happens to be the neighbor of the victim, and they are known to each other for quite some time. The victim has been examined before the court as PW1, and she has completely denied the allegation and has turned against. He submits that the petitioner is in custody since
2/5/2026.
2/5/2026. The learned counsel for the state has opposed the prayer for bail. However, the posted submissions made by the counsel for the petitioner are not in dispute. A copy of the deposition of the victim has also been produced before this court. आपने देखा है? देखा. It has been produced by the learned counsel for the state. After hearing the learned counsel for the parties and considering the fact that victim has turned hostile before the learned court, and also the custody, the petition is added to the motion.
Item 16, BS6716/2026.
Case petition.
Yes. The matter has been lodged for the offense in the section 81, 238, 61, subsection 3, 5 of the laws, corresponding to 304B, 120. The petitioner before the lawsuit is the mother-in-law, father-in-law, and brother-in-law of the deceased. And the husband and one elder brother-in-law has already been admitted by the trial court. I have annexed their answer to his
How are we concerned with their equity? We are not concerned. We
only
are not
because
concerned with their equity. We
why
cannot participate in the trial,
yes,
right?
what
So you
on
cannot
what
take
ground
any
they have been acquitted, that
whatever.
is
We are not bothered about it.
देखो इसलिए है क्योंकि ये एफआईआर जो हुआ है वो 2/9/2024 पे है is 12. Though in the ending of the judgment it has been mentioned that there is overacting in the FIR which appears from the FIR itself.
Judgment आप जिसमें participate नहीं किए वो judgment कौन क्या देंगे?
That trial is also
आपका ट्रायल होगा ना?
हाँ.
तब आप अपना बहस करिए.
The husband is the prime accused and he has delivered the petitioner. Number 1 is the
FIR देख. FIR पढ़ी.
FIR page 14.
आप लोग भागे हुए क्यों?
क्योंकि इसमें पुलिस का जो रोल है वो बहुत
नहीं, आप बताइए ना, आपका रोल सस्पिशियस नहीं है, आपकी बहू मर गई है,
इसीलिए तो वो
पुलिस का रोल सस्पिशियस है,
इसीलिए वो दिखा रहे हैं.
कितना दिन में मरी है?
3 days as per the
3 days
21/4/24 को मैरिज है. 5 महीने में 2/9 as per the FIR 2/9/2024 को FIR में 1/9 को घर से गायब होती है और 2/9 को उनका बॉडी ये
तो 2/9/24 को she was found dead.
हाँ.
Where was she found dead?
In a well.
In a well where? घर के पास, घर से दूर, कहाँ?
घर से दूर एक गांव का एक कुएं में उनका बॉडी मिला, वो भी आधा जला अवस्था. और जबकि जो
आधा जला हुआ अवस्था.
Yes.
Half burnt, right?
Yes. और ये है इनके डिपोज इनके
हस्बैंड का एक्टिव कर लेते हैं.
हाँ. और उनके एल्डर ब्रदर क्योंकि इसमें आया हुआ है से एक बार केवल पेज 30 देखा जाए. पेज 32
एक सेकंड. The informant has not produced on record any document nor the investigating officer established when the marriage took place. ये आपका एक्यूटल ऑर्डर है.
हाँ ये भी लिखा है.
आपको नहीं पता है शादी कब हुआ था?
हम तो लिखे 21/24
तो एडमिटेड है ना कि मतलब विदिन 3 months she
और
died.
वो चीज नहीं प्रोड्यूस.
वही तो बहुत चीज नहीं
Inquest
प्रोड्यूस
report
होगा, वो
नहीं आया.
समझ में आ रहा है.
Inquest report is also not on record.
अब सब आएगा.
Postmortem report is also not on record. Doctor has also not been
They
examined.
will all be examined when your case will be tried.
Why? Because कि
Why मतलब?
क्यों नहीं हुआ है वो बता रहे हैं.
They will come, don't worry.
क्यों नहीं हुआ है वो बता
इस
रहे हैं.
दुनिया में है ना वो लोग. आइयो डॉक्टर.
एग्जामिनेशन जो हुआ है ना वो 31/7 इनका जो केस है वो 31/7/2024 को लेडी घर से गायब हो जाता है. उसके बाद ये केस होता है 31/8 इन लोग कहते हैं कि 31/8/24 को वो घर से गई, उसका हमको इंफॉर्मेशन मिला, 1/9 को डेड बॉडी मिला, जबकि एक्चुअल इंसिडेंट होता है 31/7/2024 एंड आफ्टर 2 months दिस एफआईआर हैज बीन लॉन्च्ड. कॉज ऑफ डेथ हैज नॉट बीन असर्टेड कि क्यों कौन
हाफ बर्न डेड बॉडी मिला है ना वेल से,
वो भी इसका आइडेंटिफिकेशन नहीं है.
द बॉडी हैज नॉट बीन आइडेंटिफाइड. तब की बहू कहाँ गायब हो?
इनका डीटी पता देखिए.
हम तो इंफॉर्मेशन दिए कि वो
बहुत गायब हो रही है, बट ये
इसीलिए इसमें एक बार केस डायरी मंगा लीजिए, उसमें सारा आता है.
कुछ केस डायरी नहीं मंगाना.
एक दिन इसमें
नहीं, आप इतना दिन तक गायब थे, अब हमारे लिए इतना ही बहुत है.
वो तो है,
आराम से आप जेल में.
लेकिन पुलिस का रोल भी इसमें संदिग्ध है.
आपका रोल तो बहुत ही बढ़िया.
मेरा तो ये तो डॉक्टर इन लॉ है इसकी, तो अब उसके बाद
इन लॉ है ना, शादी हुआ था ना,
शादी हुआ तो
वो भी नहीं हुआ.
शादी तो एडमिटेड है.
लग नहीं रहा है आपका एक्यूटल ऑर्डर से. डेट ऑफ मैरिज इज नॉट नोन टू द हस्बैंड.
इन्फॉर्मेंट आल्सो नॉट गिवन.
ये तो वही तो
फादर है इन्फॉर्मेंट.
अरे भाई फादर है इन्फॉर्मेंट. आप तो हस्बैंड थे जो भी थे टू फेस द ट्रायल एंड द कोर्ट सेज दैट डेट ऑफ मैरिज इज नॉट नोन.
फाइंडिंग में आया है
कोई बात नहीं, वो उसका आपको कोई बेनिफिट.
ये 21/4/24 को उसका हुआ है, ये शादी को आया होगा पेज 30
Considerable factors are it appears that death of deceased within 7 years of her marriage. As he was married to accused Ajit Jawad Nikis Chowk.
First,
That is there.
heard the learned counsel appearing.
Interpolation in the FIR is there. Postmortem report नहीं है.
ठीक है, ठीक है.
Lots of 304
Heard
B
the
taken.
learned counsel
Lots of-
appearing on behalf of the party.
Essential ingredients of 304 B is also not present.
आप अपना एक quashing application फाइल कीजिए. The entire criminal case will be quashed.
Prima facie it
Prima
appears.
facie. We are seeing the prima facie.
क्योंकि
आप
इसमें
सुन लिए ना आपको. First, heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioners happen to be the father-in-law, mother-in-law, and brother-in-law of the deceased, who expired on 2/9/2024. He submits that the marriage was solemnized on 21/4/2024, and half-burned body was recovered from a bed. The learned counsel submits that the petitioners have been falsely implicated in this case. The husband of the deceased has faced the trial. The husband of the deceased and his brother have faced the trial for charge framed under section 80/2/2/3/2/3/3/5 of BNS, and they have been acquitted. He submits that at the stage of trial, neither IO,
the idea having the doctor
the doctor was not examined,
inquest postmortem that has not brought on.
and therefore the inquest and postmortem report was not brought on. The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioners are named accused and they have avoided arrest, due to which the other two co-accused only faced the trial. He submits that the acquittal of the co-accused has no bearing in this case. The fact remains that the daughter-in-law of the petitioners died within 5 months of marriage, and the body was recovered in a half-burnt condition from the bed. And there is allegation of demand of life. After hearing the learned counsel for the parties and considering the allegation made in the FIR with regard to demand of dowry, and the petitioners are named accused in the FIR, this court is not inclined to enlarge the petitioners on bail hence. Counsel for the informant.
Item 15 BA 6723 of 2026.
Yes. FIR पढ़ी? FIR. Yes.
That the place of occurrence is a busy place, marketplace, where it is a shop, where the petitioner is working for last 10 years as his staff.
That's
That meeting number 1 is going to अचानक मैंने स्विच बंद कर सीसीटीवी कैमरा बंद कर दिया और मेरी बेटी को गंदी जेल से पकड़ करते हुए उसका पेट सो मेरी बेटी जब चिल्लाने लगी तो उसके मुंह पर बंद कर पास पर पकड़ दिया तभी एक ग्राहक nobody has been examined during investigation के आ जाने की पहुंच गई फिर विपिन के मोबाइल को छीनकर मेरी बेटी अपनी मां को फोन करके बोली कि किसी को जल्दी भेजो मैं घर आऊंगी फिर मेरा भाई तुरंत दुकान गया और बिना कुछ विपिन को ही बोला कि वह बेटी को घर छोड़ दे। मेरी बेटी को बाइक से घर छोड़ने के दौरान वह उसे धमकाता रहा और वह घर पर किसी को ना बोलने, नहीं तो वह उसके पिता को जान से मार देगा।
डायरेक्ट एलिगेशन है।
Yes.
13 साल की लड़की है, क्या
Yes,
बताएं
Lord.
बताइए।
मेरा है कि मिलट there was some due मिलट सैलरी का डिस्प्यूट था जिसके चलते ये केस हुआ है। दूसरा
See this
during
30 years, 30
maximum
years.
punishment is 3 years under these sections, all these
Also maybe.
3 years to 5 years. That is maximum. That is as per
कौन से सेक्शन में?
section 8.
किस सेक्शन में चार्ज फ्रेम हुआ?
Section 8.
और 74, 75, 351
उसमें 1 से 3 साल, 1 से 2 साल मैक्सिमम पनिशमेंट यही है। और डिस्प्यूट क्या है? सीसीटीवी कैमरा बोलते हैं कि मैंने स्विच ऑफ कर दिए। इन्वेस्टिगेशन में ये चीज सीसीटीवी कैमरा को ये करना चाहिए कि वेदर ड्यूरिंग दैट पीरियड ये स्विच ऑफ था कि नहीं, ये भी नहीं है। कहते हैं ग्राहक पहुंच गया, इट इज अ बिजी मार्केट प्लेस में, कोई वो ग्राहक भी नहीं एग्जामिन है कौन ग्राहक थे कौन, अगल बगल दुकान है, कोई दुकानदार नहीं है, कोई सिर्फ फैमिली मेंबर्स है, सैलरी का ड्यू था, इसी के चलते ये केस हुआ है, झंझट हुआ। 10 साल से उनके यहाँ काम कर रहे हैं और उसके बाद फिर हम उसको घर भी पहुंचा दिए मोटरसाइकिल से।
तो आप सब कर करा के पहुंचा दें।
हाँ यही है, दिस इज द यही एलिगेशन है। एज पर this the maximum punishment that can be imposed under section 8 is 3 years, minimum 3 years and maximum 5 years.
Minimum 3 years है ना?
Yes, minimum 3 years, that I am saying, not minimum 3 years and 5 years. In all other sections it is 1 to 5 years. 74 में 1 to 5 years, 75 में up to 3 years, 351 में up to 2 years, 352 में up to 2 years. This is the maximum.
Council secretary on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, primarily on account of certain dispute regarding payment of salary. However, he has further submitted that so far as the case is concerned, it has been registered under section 74, 75, within bracket 2, 351, within bracket 2, 352 of BNS and under section 8 of the and in the sections under BNS Act, the maximum punishment is 2 years.
BNS in 74 it is minimum 1 year, maximum 5 years, and other sections is maximum.
ठीक बोल रहे हैं आप?
एकदम एग्जामिन करके लिख के रखते हैं, इसलिए हम बोल रहे हैं, at least it can be verified from the record.
And under section 8, the minimum punishment is 3 years and maximum punishment is 5 years. The petitioner is in custody since
1/4/26.
Since 1/4/26. Stage of trial क्या?
The charge has been framed on 4/6/26.
And charge has been framed on 4/6/2026. The learned counsel for the state has opposed the prayer for bail and has submitted that there is direct and specific allegation against the petitioner. And as per the appeal order, the statement of the victim was also recorded under section 183 BNSS, and she has supported the allegation against the petitioner. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail hence retained. However, the state is directed that the witnesses are promptly produced before the court. Also, the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution.
Item 16 BA 6730/2026.
Allegation against the petitioner is that informant was informed by some of the villagers that a woman has been murdered by his husband And thereafter, when he went to the house, he found the woman lying dead, and the villagers informed that she has been killed by her husband.
Where was the husband? You are the husband?
Yes, Your Lordship.
He was killed at home?
Your Lordship, none of the witnesses have supported the case, Your Lordship.
She was killed at home?
She was
He
lying
was
dead
found dead at home?
at home, Your Lordship.
When was the marriage solemnized?
Yes, 5 years back, before the incident.
And what is the FIR?
Yes, Your Lordship.
Who has lost the FIR?
Some,
The trial is
stranger-
on. How many witnesses have been examined?
Your Lordship, out of 8 witnesses, 5 witnesses have been examined. However, Your Lordship, since December 2025, the prosecution has not been able to adduce any witnesses.
Out of 8, 5 have already been examined.
Yes, and the last
So
witness was
24,
examined on
26.
3rd of December 2025. The informant has also not been examined.
Or the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband and his wife was found dead at home. However, the petitioner has been falsely implicated in this case. And petitioner has no criminal antecedent. He is in custody since 3/6/2025. The learned counsel has also submitted that the marriage was solemnized between the petitioner and the deceased 5 years prior to the date of the incident. The learned counsel for the state has opposed the prayer for hearing and has submitted that the petitioner caused death of his wife by assaulting her by means of iron or a mallet. And she died due to head injury. He has also submitted that the trial is in progress. Out of 8 charge sheet witnesses, 5 witnesses have already been examined. At this, the learned counsel for the petitioner has submitted that since December 2025,
Last witness was examined on 3rd of December 2020.
since December 2025, no witnesses are turning up, and petitioner is in custody. After hearing the learned counsel for the parties and considering the nature of allegation against the petitioner who happens to be the husband of the deceased found dead in a matrimonial home, this court is not inclined to enlarge the petition on bail. However, there can be no excuse on the part of the state not to produce the witnesses. The state is directed to ensure that the remaining 3 witnesses are promptly produced before the court. What is the next date?
Your Lordship, the next date is 28th of August 2020.
28.
28th.
The learned counsel for the petitioner has submitted that the next date in the trial is on 28th of August 2026. The learned counsel for the state is directed to communicate this order to the SP of the concerned district and to direct the prosecution so that the remaining 3 witnesses are also promptly produced before the court so that the case is taken to a logical end. Any FSL report awaited?
Not in now, Your Lordship.
Not sent for any FSL.
Your Lordship, the charge sheet shows that some laboratory reports are there, but it has not been produced till now.
The learned counsel for the state is also directed to communicate this order to FSL countries so that the FSL report is also promptly forwarded to the court.
Item 70, BS 6737 of 2026.
This petition.
Filed under section 96, 65(1) and BNS and 6 of Postcode. May I read the requirement?
Yes.
निवेदन पूर्वक सूची प्रकार में प्रकाश साफ दिखा रामचंद्र साफ राम इंद्रानगर जयदेव थाना जनता जिला में झारखंड की रहने वाली हूँ। मेरे सचिन सबकी उम्र 14 वर्ष है। दिनांक 30/10/2025 को शाम 8 बजे से
कहाँ से रिकवर हुई है?
रिकवर नहीं हुई
रिकवर नहीं हुई।
वो नहीं वो आई है दिल्ली में छोड़ दी उसको। दिल्ली से फिर पटना आई।
दिल्ली से पटना आया, पटना से घर आ
पुलिस के द्वारा
उनका स्टेटमेंट रिकॉर्ड हुआ वाला 183 में। So victim age 14 to 15 years was taken to Delhi by the petitioner on pretext of marriage.
marriage he is the marriage person he having a children
उसका साथ दिया था, बोल रहा कि शादी करने के लिए लेके गया, ऐसा कुछ है नहीं।
नहीं मतलब victim का स्टेटमेंट नहीं रिकॉर्ड हुआ है।
टीम का स्टेटमेंट रिकॉर्ड हुआ है,
काफी
but it is not
victim would have disclosed no what has happened to her.
साथ में लेके गया था।
साथ में लेके गया 14 साल की लड़की को लेके गया, काफी है।
183 का स्टेटमेंट मंगा लीजिए, नो एंटीसीडेंट नो
183 का स्टेटमेंट का साथ एंटीसीडेंट का कोई लेना देना नहीं है। The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case.
स्कूल जाने का टाइम कोई नहीं देखा, वो भी एफआईआर कर रहे हैं 5 दिन के बाद।
Counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit with the statement of the victim recorded under section 183 basis before from the concerned court, along with the case diary and its enclosures. Post on 12th of August, the counter affidavit will be filed by 7.
Item 18, BS 6741 of 2026.
Filed section 64(1) 115(2)(26). Page 15 is the FIR. निवेदक को कहना है कि मैं रीना मतलब उम्र सर्जन सच प्रति सर्जन सच थाना चौका जिला सरायकेला का समाज में रहने वाली हूँ। मेरे पति गाड़ी चलाने में काम करते हैं। आज भी पति काम पर गए हुए थे, तभी समय करीब 12 बजे दिन में मेरे गाँव का ही रघु माथुर पिटिशनर मेरे घर आया तथा मेरे साथ मारपीट करने लगा तथा मुझे अपने घर ले गया तथा अपने घर का दरवाजा बंद करके मेरे साथ जबरदस्ती करके सारे सिग्नल बनाया। मेरे हल्ला करने पर गाँव वाले आकर दरवाजा तोड़ के मुझे बाहर निकाले, तब तक पुलिस वहाँ पहुंची जिसके बाद कानूनी कार्रवाई करी।
On behalf of the parties, the learned counsel for the petition submits that the petitioner has been falsely implicated in this case. Counsel for the state has opposed the prayer for bail and has submitted that there is direct and specific allegation of committing rape upon the victim by the petitioner in the FIR itself, and the victim is the informant of this. After hearing the learned counsel for the parties and considering the direct and specific allegation made against the petitioner, this court is not inclined to believe as the petitioner.
Litigation charge has been framed and 4 witnesses have been examined, so that observation.
At this, the learned counsel for the petitioner submits that 4 witnesses have already been examined out of 8 witnesses. He submits that he will be satisfied if appropriate observation is made with regard to expeditious examination of the remaining witnesses. The state is directed to ensure that the remaining witnesses are found with before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the Director of Prosecutions and
DT of
Item 19, BS 6745 of 2026.
Yes, petitioner.
The FIR is registered under section 103, 238, 235 of BMS. Ready to FIR.
Yes.
सभी लोगों ने कि मैं अनीता देवी हूँ सच एड्रेस इस आई वासी हूँ मेरी पुत्री रीता देवी की शादी विगत 10 वर्ष पहले सुबोध रवानी पिता सच जिला जामताड़ा के साथ हिंदू निवास के साथ किया गया दिनांक 5/3/26 को मेरे दामाद सुबोध रवानी से मोबाइल द्वारा पता चला कि मेरी पुत्री लापता है। उसके बाद हम लोग पूरे परिवार के साथ ग्राम सच पहुंचने पर पति सुबोध रवानी ने बताया कि घर से कहीं चली गई है। हम लोग खोजबीन लगभग 4 दिन करने के बाद आज दिनांक 9/3/26 को ग्रामीणों द्वारा सूचना मिली कि ग्राम तेलियाडी के कुआं में एक महिला का शव मिला है। वहां पहुंचने पर देखे कि मेरी ही पुत्री का शव है। दावा है कि उस पर्सन सच दिलीप रवानी छोटू रवानी एंड मुझे पूर्ण विश्वास है कि चारों व्यक्ति मिलकर मेरी पुत्री को मारकर कुआं में फेंक दिस इज द एलिगेशन आफ्टर दैट charge sheet has been submitted under section 108 and charge has been framed
108 and 35.
yes and the informant has also been examined in leadership and she has stated in her examination in chief that I have no knowledge in what has been written in the complaint.
Where is that?
And in the impugned order, it has come that that is due to reason of death.
Especially due to down.
Yes.
The learned counsel for the state is directed to serve notice upon the informant and file a contact affidavit in this case. There is the case diary along with the postmortem report and also the inquest report for 174. Postmortem report taken report. The count affidavit will be filed by 7. This is based on 12th of August. And where is the husband?
He is also in custody.
Item 20, BA 6746 of 2026.
Yeah, the office is 1664 1 321 2 of the business. So that as per the release.
If I happen.
Page number 19. निवेदन सविनय निवेदन है कि मैं सो यूपी जिला निवासी हूँ। मैं दिनांक 1/26 को बड़ा जामदा बाजार आई थी। शाम करीब 7 बजे जब मैं बाजार के वापस पैदल लौट रही थी तब सोहन सोरेन पिता सोरेन ने रास्ते में मिला। सोहन सोरेन से मैं पहले से परिचित थी। सोहन सोरेन मुझे जबरदस्ती हाथ पकड़कर अपने घर 15 साल ले गया और घर के बाहर बने तिरपाल के झोपड़ी में मिलाकर जबरदस्ती करने लगा। मैं चिल्लाई और अपने का प्रयास किया लेकिन वह नहीं माना और मेरे साथ जबरदस्ती किया। वह धमकी दिया किसी को बताइए तो जान से मार। फिर समय करीब रात 9 बजे मुझे मेरे घर पता हाथू पहुंचा दिया। डर से मैं मेरी शादी रहती थी। आज दिनांक 11/6 में अपने बेटे को delay in the FIR. Victim is 54-year-old lady and the petitioner is 58-year-old. And also the house of the occurrence place is the house of the petitioner. The family members is also present at the evening of the occurrence night. So no one see the occurrence. And also the petticoat and the blood sample of the petitioner sent to FSL report is. I have been custody since 1926.
19?
1 January 2026. Charge was framed on 6/6/2026. No witness.
Or the learned counsel supporting on behalf of the parties, the learned counsel for the petition submits that although there is direct allegation in the petition in the FIR, but the date of incident is 13/1/26 and the FIR has been lodged on 17/1/2026. The learned counsel further submits that there is no eyewitness to the occurrence, although the place of occurrence is the house of the petitioner. And the victim is 54 years of age, the petitioner is 48 years of age. The petitioner is in custody since 19/1/26. The charge has been framed on 6/6/2026 and no witness has been examined so far. The learned counsel for the state has opposed the bail for this and submitted that there is direct has submitted that there is direct and specific allegation against the petitioner and the medical examination report as mentioned in the interview order itself reveals that the victim was subjected to sexual assault. After hearing the learned counsel for the parties, to this counsel for the petitioner submits that the prison report is still awaited. After hearing the learned counsel for the parties and considering the direct and specific allegation level against the petitioner, which is also supported by medical evidence, this court is not inclined to enlarge the petitioner on bail. However, there can be no reason not to examine the witnesses before the court and for non-production of official report to the concerned court. The learned counsel for the state is directed to ensure that the witnesses are promptly produced and the official report is also forwarded to the court. Counsel for the state is directed to communicate this order to the Director of Prosecution and also to the SP of the concerned district and get a copy of this order being forwarded to FSL Ranchi so that the FSL report is also forwarded to the court concerned.
Yeah.
Item 21, DA 6748 of 2026.
Yes, petition.
जिला जामताड़ा के रहने वाली मेरी नानी फ्रेंड्स को ग्राम से मिला है जो राज्य के विश्वविद्यालय में फतेहपुर में वर्ग नवम की छात्री है। दिनांक 21/4/2026 को समय करीब 9 बजे सुबह रोज की तरह स्कूल जाने बोलकर घर से निकली और वापस लौट कर नहीं आई तो हम लोग को चिंता बढ़ गई। अगल बगल खोजबीन कर कोई पता नहीं चला। खोजबीन करने के क्रम में रिश्तेदार से पता चला कि मेरे नानी नवानी लड़का को आकाश दत्त की गलत नियत से जबरन भगाकर ले गई है। इसके भगाने में उसका माँ एवं पिताजी तथा रूपा के पति समेत एवं समीर गुप्ती का स्वयं का पूरा हाथ है। इसके बाद हम लोग आकाश दत्त की माँ एवं पिताजी से संपर्क किया तो बोला हम उसे वापस बुला देंगे, परंतु आज तक वापस नहीं बुलाया। बोलने पर जान मारने की धमकी दे दी। तब से घटना है 21/2026 का, लेकिन 17 days का डिले में FIR लॉन्च।
Actually, they were asking to produce the child. What is the statement of the victim under 183 BNS?
183 का statement है नहीं, लेकिन 180 का statement है जिसमें कुछ बोली है कि पढ़ देते हैं। फतेहपुर थाना कांड संख्या 14/26 दिनांक 7/5/26/96 की तहत पीड़िता का बयान BNS की धारा 180 के तहत लेना प्रारंभ की निवासी के करीब 1 साल से जानती हूँ। हम दोनों एक दूसरे को पसंद करने लगे, फिर एक दूसरे से प्यार हो गया। हम दोनों एक दूसरे के साथ रहना चाहते हैं, इसलिए मैं आकाश दत्त के घर से भागकर मैं आकाश दत्त के घर चली गई और
कहाँ चली गई?
आकाश दत्त के घर चली गई, भागकर आकाश दत्त का घर चली गई और उसी के साथ रही। हम दोनों पति पत्नी के रूप में रह रहे थे और मुझे उसी के साथ रहना है। यही मेरा ये वाणिज्य का स्टेटमेंट में बोली है और CWC का भी स्टेटमेंट जो है
She is just 14 years of age. It's a matching age भी। 20 years, 20 साल और 14 साल में बहुत फर्क।
14 years, more than 14 years। और मेडिकल में भी वो अपना दादी के कंसेंट से डिनाई किए। मेडिकल में उसका दादी का भी सिग्नेचर है, उसका विक्टिम का खुद सिग्नेचर है कि मैं
From where was she recovered?
थाना से मिली है।
दोनों साथ थाना में तो कोई आया होगा ना?
दोनों पिटिशनर के साथ ही आई थी, जिसे जहाँ से उसको
Basically she has been recovered from the custody of the petitioner. Both of them
but Lordship 183 का स्टेटमेंट भी 180 से फॉरवर्डेड है, सेम स्टेटमेंट। और इंडिपेंडेंट विटनेस भी बोला है लॉर्डशिप कि वो अपने मर्जी से भाग कर गया था, कोई इसको भगा के नहीं ले गया। स्कूल का बहाना बना
कस्टडी कब से?
7/5/2026।
चार्जशीट कब हुआ?
चार्जशीट है हुआ लॉर्डशिप 20/6/2026।
क्या बोलना है आपको?
माइनर गर्ल है।
शादी कर लिए, घर में रह रहे, पेरेंट्स क्या कर रहे? पेरेंट्स एक्यूज नहीं है?
पेरेंट्स को भी है लॉर्डशिप एक्यूज है, इसमें जनरल एंड ऑमनिबस एलिगेशन है।
नहीं, किसी के घर में 14 साल की लड़की बहू बन के आ जाएगी तो सीरियस है।
लेकिन लॉर्डशिप वो अपने मर्जी से रह रही थी, जो स्टेटमेंट में भी है।
मर्जी से रह रही थी तो कोई रख लेगा?
लेकिन वो तो मर्जी से ही रह रही थी लॉर्डशिप। 183 का स्टेटमेंट भी उसमें कॉर्पोरेट करता है 183। और मेडिकल में भी वो डिनाई कर रही है और उसमें उसका दादी का भी कंसेंट है, उसमें उसका सिग्नेचर दिया दादी। विटनेस भी सब यही होता है कि वो अपने मर्जी से भाग कर गई थी, उसको कोई भगा के स्कूल का बहाना बना कर गई।
और the learned counsel supporting on behalf of the parties. Counsel for the state is directed to serve notice upon the requirement of the case and file a counter affidavit. Let the case directly along with the state recorded under section 183 BNSS be called for from the concerned court. The counter affidavit will be filed by 7th post on 12th August.
Permission item 22. BA 5016 of 2026.
Yes, petitioner.
Custody since 6/1/2026, 7 months. Recovery of one mobile account C. All of that as per the counter of the crime link of is there.
How many crime links are there?
There are 5 now.
Counter 5?
Yes.
Counter they are actually.
Which is counter? Antecedent of similar nature.
Yes, that therefore it was withdrawn earlier.
तो आपने कितना जल्दी तुरंत क्यों फाइल कर?
3 महीना
3 महीना क्या?
7 महीना
तो बताए थे आपको 9 महीना का
नहीं,
टाइम
तो
देंगे।
इधर बोले थे, बीच में दे रहे थे, इसी के लिए फाइल किए।
क्राइम लिंक भी दिए हुए चीज।
क्राइम लिंक भी आपका बहुत है।
नहीं, बहुत नहीं है।
बहुत है।
7 है।
क्या नाम है? अरुण दास।
अदर्स का भी
टोटल अरुण दास का ही है। यही नंबर 12 में।
अदर्स का भी था क्राइम लिंक, सिमिलर ज्यादा था इनसे, मगर उन लोगों का एंटीसीडेंट नहीं था। देवर ऑल अदर्स वर ग्रांटेड
11 crime links of different states.
yes, but no case will not, and all others, the others also having crime link will not has been granted bail by you. सिर्फ एंटीसीडेंट नहीं था, इसीलिए उन लोगों का बेल हुआ। और हमारा एक एंटीसीडेंट था 7 months once discussed. All other quake is done.
Para 47, 48, and 53, 65 also good. 56.
क्या करते थे आप? What was the modus operandi?
कुछ नहीं ये करते हैं कि जो कि ये लोग they are all are involved in
Payment bank customer बनकर.
हाँ वही this is the they against all these petitioners the
Cashback.
same nature as subject law. This long EP model is there.
Payment.
नहीं antecedent है तुरंत.
Yes, that antecedent is there. That I have admitted.
That's
That is not.
Admit करके आसान नहीं की.
नहीं नहीं that was earlier also it was there and other quake was
नहीं नहीं, you see there has to be some standard. 9 महीना के पहले हम
इसको कर दिया जाए तो it is a kind of matter because बार-बार फाइल करने में
दोबारा खोलते
बार-बार फाइल करने में
नहीं हम आपका केस इस तरह से adjourn करके नहीं कर सकते. We are also answerable to many people why the case is pending. ये number 5016 आपको observation हम दे देंगे.
we not renew after 2 months में 2 महीना में हो जाएगा.
ये number 5016 of 2026. For the learned counsel appealing on behalf of the parties, counsel for the petitioner submits that the petitioner is in custody since 6/1/26 and has one criminal antecedent of similar nature, but other accused persons have been enlarged on bail. The learned counsel for the state has opposed the prayer for bail and has submitted that as many as 11 findings have been found against the petitioner relating to different states. And it is a case of organized crime as the charge sheet has been submitted under section 111(2) within bracket B /111(3/111(4/319 within bracket 2 /318 within bracket 4 /338 /336 within bracket 3 /314 within bracket 2 and 61(2) of BNS and section 66B C D/84 of Information Technology Act. The page 7 of the contract. After hearing the learned counsel for the parties and considering the nature of allegation and the crimes found in connection with the petitioner, this court is not inclined, and the petitioner has a criminal antecedent. This court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after 4 months.
9 months तो ही मेरा बात हो
ना calculation नहीं है.
मेरा 9 months कर दिया जाए. After
Item 23, BA 5017 of 2026 along with 24.
In this case, this is also earlier withdrawn, but the antecedent that is there, that is subsequent, not of this. इस केस में जब पकड़ाए हैं, इस IME तब एक केस होता है लातेहार में 2026 में. इस केस में पहले पकड़ाए 15 इस केस में फाइल होने के बाद जो लातेहार में एक केस होता है on the IMEI number of the present petitioner. On that basis, the petitioner has been remanded in that case. That is the only antecedent.
One subsequent case you have been remanded.
Yes, no previous case. On this basis, I have been remanded in another case in Latehar. And previous
क्या नाम है आपका?
मेरा
नाम क्या है?
रमेश कुमार दास.
रमेश कुमार दास. इनके अगेंस्ट क्या है?
Yes, and
Lordship, I am mentioning para 8 lordship. number of criteria was found on the portal. That is amount to like the information by the elected lordship, that is UP, Jharkhand, Maharashtra, everywhere he has cheated the and defrauded the customers. I have mentioned in para 8 of this. And two victims in this case, lordship, every amount has been deducted from their account. That I have mentioned 12 and 30 my account. Two victims in this case.
The learned counsel appealing on behalf of the parties. The learned counsel for the petitioner summons the petitioner has been falsely implicated in this case. However, after the present case, the petitioner has been remanded in another case of similar nature. Which is Latehar PS case number 3 of 2026. The learned counsel for the state has opposed the prayer for bail and has submitted that there are numerous findings against the petitioner found during investigation and of different states, and three victims have already two victims have already been identified. To this counsel for the petition submits that the petition is in custody since 3/1/2026 and charge sheet has been submitted.
Yes, charge sheet has been submitted.
On
No.
and charge sheet has already been submitted.
On notice
29/3/20. It is not under our organized name. But 3/19/2 and
We have submitted that the charge sheet in the present case has not been filed against organized crime in connection with the organized crime. After hearing the learned counsel of the parties and considering the fact that the previous case was instituted against the petitioner prior to the present incident and the custody of the petitioner since 3/1/2026, the petition is directed to be national bail. दूसरा केस
सेम है, इसमें भी वही लातेहार केस में रिमांड हुए हैं सब्सिक्वेंट।
इसमें कितना टाइम है?
उसका स्टडी वही सेम पीरियड में
क्राइम लिंक पूछ रही थी।
यहाँ पर दो विक्टिम है जो 9,500 था 59,500
और 9,500 two victims are there and one criminal antecedent.
सब्सिक्वेंट
एंटीसीडेंट है कि
One criminal antecedent.
बाद में है
लातेहार
थाना पुलिस केस नंबर 32 of 2020.
Yes, that I have stated para 15, but I have stated para 15 में हम
Or the learned counsel is appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. However, the petitioner has a criminal antecedent of
para 15 not of my petition.
Yes, 155 of
2020.
of case number
135 of 20.
135 of 20 देवघर PS case number 135 of 2024 और ये वाला किससे realize कर and another case of Jandipur cyber crime case number 32 of 2024 and a third case Latihar cyber PS case number 3 of 2026
3 of 26 Lord, that is this present case in which both the persons were remanded after.
The learned counsel submits that so far as the Latihar case number 3 of 26 is concerned, the same has been instituted after the present case. The learned counsel for the state has opposed a claim for bail and has referred to the criminal antecedent report of the petitioner and has submitted that there are numerous findings found against the petitioner relating to different states. After hearing the learned counsel for the parties and considering the numerous findings and also the other criminal cases instituted against the petitioner which are of similar nature, this court is not inclined to enlarge the petitioner on bail.
This is taken
कोई observation नहीं है और आगे bail भी नहीं है
because it is not on.
कोई बात नहीं Yes. Okay.
Item 25, BA 5021 of 2026 allowed to 26
Pass over
27.
नहीं होता counsel for the petitioners raise for them no जो भी है आज इतना टाइम नहीं है चार केस tomorrow supplementary में आ जाए
Item 28, BA 5023 of 2026.
tomorrow raise for time post tomorrow
Item 30, BA 5147 of 2026.
Study since 15 12 2025.
yes 15 20 25
Yes.
this what has been recovered
Lord, one mobile without SIM,
one mobile no SIM
no SIM. Charge has been framed on 11/5/2026.
antecedent
Below the antecedent, Lord, yes, they have filed affidavit, Lord, with regard to incident, Lord.
how many cases
Lord, effective case, but Lord, I am very after this arrest in this case, Lord, he has been remanded in one case. That is,
where is the counter
yes, Lord, you not
they are not filed it.
Lord, they kindly tell this.
Received diary yesterday.
Where is the counter
One week time to be given.
You
Also
not
for
see
the
the
state
kindly
case
tell that order.
praise for time to comply the last one close this case on 3rd of August the contract will be filed by 31st 31 तक कर देंगे
30.
by 31st
Next.
Next, कौन?
वो order जो है, इस पर।
ये 30 चल रहा है ना?
ठीक है, इसमें नहीं काम करने
काम कर रहा है।
There is no antecedent.
Next is my last.
Item 31, BA 5150 of 2026.
Not one mobile without SIM. After his arrest, Lord, he has been remanded in a case in Lord.
earlier withdrawn
Lord, yes, he is in custody since 15/12
one mobile
without SIM.
without SIM please
Charge has been framed, Lord.
custody
Custody Lord 15/12/2025. Lord, after his arrest, Lord, he has been remanded in one case in Rajasthan in which the learned police invested has started. And apart from that, there is no other case.
अभी आपका केस मैच्योर नहीं है
Lord, 15-12 से after his
15-12 से कितना महीना हो गया
8 महीना कंप्लीट 8 महीना कंप्लीट हो गया
कोई बात नहीं
Lord, और कोई के उसके बाद कोई एंटीसीडेंट है नो एंटीसीडेंट
it's a case of organized crime right
Lord, no antecedent.
it's a case of organized crime
It is no antecedent, no victim. There is one victim of 37,000, 3,700. उसी में And apart from that, there is nothing. 8 महीना
कहाँ है स्टेट? Yes, are you there? Okay.
both of them submit कर देना मुझे.
अब बताइए क्या बोलते हैं?
One victim है, one criminal antecedent है, 2 crime link है लॉर्डशिप.
One victim.
Yes. One victim, one criminal antecedent, 2 crime link.
One antecedent, 2 crime link, and
Crime link is verified and no FIR था. One का जो ये criminal antecedent है वही वेरीफाई करके है, और सेकंड का जो पाया गया कि उसका
2 पिटिशनर है क्या?
नहीं, उसका 2 क्राइम लिंक पाया गया. एक क्राइम लिंक से एक FIR था जो क्रिमिनल एंटेसिडेंट है, और दूसरा क्राइम लिंक के बारे में जांच किया गया
नहीं, वो राजस्थान में इसलिए
उसमें बेल
बेल ऑफ दस. और दिल्ली काउंसिल से
अगर वन को एक चीज का रिजेक्ट हुआ लॉर्डशिप एंड 5 का
5 आदमी का अलावा
एक खालिद है कोई तो उसका रिजेक्ट हुआ ट्वाइस. बी 8826 उसी का सेकंड टाइम 591226 और नंबर 6 से रिजेक्ट हुआ ट्वाइस.
और दिल्ली काउंसिल से appealing on behalf of the parties. The Learning Council for the petitioner submits that one mobile has been seized, is alleged to have been seized from the possession of the petitioner. And one victim has been identified. The petitioner is also an accused in a case registered at Rajasthan. And during investigation, 2 crime links have been found. The petitioner is in custody since 15/12/2025 and charge has been filed on 11/5/2026. The Learned Council for the state has opposed the prayer for bail and has submitted that it's a case of organized crime and the petitioner has criminal antecedent also. And the case of the accused, namely Khalid Ansari, has been rejected by court of judge. The comparative file during court proceedings is taken. After hearing the Learning Council for the parties and considering the fact that the case is of organized crime and the petitioner has another case also against him and victim has also been identified. This court is not inclined to enlarge the petitioner on bail. However, the petitioner may renew his prayer for bail after 4 weeks.
Incident 25 to 29 Lordship. That case has been tried and fixed for tomorrow Lordship. But tomorrow Lordship, one ACB matter is fixed for tomorrow. Serial 1 or 2 Lordship. So another court. So I am basing that. So let it be after.
No. I have already passed an order. If you want some adjustment, then you take or pass over. That will always be granted.
Item 32, BA 5151 of 2026.
At the outset, let me inform to this honorable court that this petitioner has earlier moved this honorable court before the bench of Mr. Justice Abdullah, as then he was. Then it was withdrawn without the argument at that stage, which order I have annexed as annexer 1 at page 18. The Learned Council for the petitioner seeks permission to withdraw this bail application. Prayer is allowed. Accordingly, the bail application is dismissed as withdrawn. This order was passed in the month of November
2025. Then we are again renewing the prayer for bail after the trial has commenced and material witnesses numbering 5 have already been examined. दो ठोका सीजन लिस्ट विटनेस का 2 ठोका हम फाइल कर दिए थे. आज एक आया हुआ है हमारे पास करंट लेके आया है. That I want to file it before your lordship, or your lordship can have a look to it. In 2 copies I have got it photocopied for my counterpart and also for this one.
So what is your point?
The case of the prosecution is that the dead body with a crushed head was found near a dilapidated or under construction house at a place of occurrence. It was people noticing the dead body informed to the police. It was not ascertained the identity that who she was. And after 2 days, the son of the petitioner lady gives an information to the police that my mother is missing. This is there in the case diary also. The station diary entry, missing report with the police.
How are you related to the deceased? How are you related to the deceased?
ये हम कैसे
हाँ, मतलब कोई relation है? कोई
Yes, yes, it has come during investigation that through Facebook chat we developed friendship with each other. The lady is aged about 29 years. She is grown up one. I am also married person having grown up daughters, and we developed friendship without the knowledge of our respective families. This is the background. So the needle of suspicion was pointed against my client. It is said that the recovery of the dead body is by the people. It is admitted case के unknown dead body पड़ा हुआ था, लोगों ने देखा खबर. When I was apprehended, there are 3 circumstances which ought to have been marshaled during investigation, that whether I was last seen in the company of the deceased lady, number 1, whether the personal articles of the deceased lady which was found scattered in a jungle was, according to me, according to the prosecution, I confessed my guilt before the police and I pointed out clearly जिसमें कि कुछ पर्स था उसमें पैसा भी था. इस तरह का यही एलिगेशन है. On that score, my prayer for bail was rejected. I am admittedly not named in FIR, number 1. The learned court below, while dismissing my prayer for bail, after halfway of the trial, what she says, I am reading it out. I am placing it. The improved order, kindly have a look to it at page 27. There are lots of comments. Paragraph 27. Sorry, page 27. Improved order. There are 10 charge sheet witnesses, and so far these witnesses have been 3 witnesses have been examined. आज के दिन में 5 हुआ है. कोई मटेरियल चीज आया नहीं है. 5वां मेरे पास है, हम बढ़ा दें. Then she said, then the learned court will say, including the 2 seizure list witnesses and rest of the witnesses are yet to be examined. The learned PP has been directed to issue summons upon the rest of the charge sheet witnesses. The merit of the case lies on circumstantial evidence and the necessary material to complete the chain of the circumstance are yet to be established. This is halfway. Admittedly, when the witnesses numbering out of 10 5 तो हो गया, improved order में लर्नड ट्रायल कोर्ट को ये नहीं मिला कि चेन कहाँ कंप्लीट हुआ. It is yet to be complete. This is the position. And your lordship, I have stated in paragraph 1 itself that I am in custody since June 2025, 20/6/2025. कोई क्रिमिनल एंटीसीडेंट नहीं है. Nobody has seen. और जो हम क्रूशियल चीज है तो उसको एसटी एंट्री जो लड़का है वो जो दिया है, that is very important. This is the part of the case type. वो बोलता है कि हम और वो accused मिल के खोजे हैं माँ को, और ये भी एडमिट करता है कि मेरे जो दुकान में वो महिला साड़ी ली, वो दुकानदार भी बोलता है कि वो अकेले आके साड़ी लेके गई है. Number 3, the son admits that though my mother got down from the vehicle of the accused, that she took another motorcycle of an unknown man, and since then she is missing. And last but not least, the latest law is very clear, Lordship is aware of that position, that in a SR case, that is special reported case including murder, dacoity, rape, etc., if an accused confesses his guilt, leading to the recovery or admitting his complicity in the offence, that ought to be recorded under videography number 1 in the presence of executive magistrate. That has not been complied. So this is the position. I am ready to face the trial.
What do you say?
Concern is also confessional statement of petition and leading to confession that murder articles.
Murder articles
belonging to the deceased and in the static place that is
open place. It is not that कि मेरा घर से निकला हम छिपा कर, it's open place.
About the learned counsels appearing on behalf of the parties. The learned senior counsel for the petition has submitted that the petition has been, that the bail application of the petition was earlier permitted to be withdrawn by the order dated 27/11/2025, as in PA number 8694 of 2025. The learned counsel submits that the petitioner and the deceased were said to be in contact with each other through Instagram, through Facebook, and the petitioner is not named in the FIR. And one body of lady was recovered by the villagers, whereby her head was found crushed. And after 2 days, the son of the deceased lost the FIR that his mother was missing. The learned counsel submits that only on account of suspicion, the petitioner has been made an accused in this case, and even the seizure has not been done as per the provision of the excess. Although there is an allegation that on the basis of confession statement of the petitioner, certain recoveries were made. The learned counsel for the state has opposed the prayer for bail and has submitted that there are enough material against the petitioner and the personal belongings of the victim of the deceased was also recovered at the instance of the petitioner, and at his instance the Aadhaar card, purse, sari and new sari was and dupatta was also recovered. And in paragraph 108 of the case diary, as per Tower location, the petitioner had made call from his mobile to the deceased 120 times since 1/5/2025 to 28/5/2025. The learned counsel has also submitted that the trial is at advanced stage. To this counsel for the petitioner has submitted that out of 10 charge sheet witnesses, 5 have been cited. But the chain of circumstances is yet to be proved, which is apparent from the review order dated 13/4/2026, as per the learned. After hearing the learned counsel for the parties and considering the materials collected during the investigation as indicated in the contract period, and also the fact that the trial is in advanced stage, this court is not inclined to enlarge the petitioner on bail. However, the state is directed that the remaining witnesses are promptly produced before the court. FSL है कोई इसमें? FSL है कोई इसमें?
नहीं, FSL कुछ नहीं है.
The learned counsel for the state is directed to communicate this order to the director of prosecution and also to the SP of the concerned district to ensure compliance.
एक खाली लिखा है सर I go down before the order. One thing that the two serial is not supporting the case of serial. जो हम गए और दिखाए और सीख किए they have not supported. इसलिए डॉक्यूमेंट दिया है इसलिए मेंशन ठीक है आपका जो इच्छा है.
The council has submitted that the Caesar witnesses have not fully supported the prosecution. Have they been turned hostile? Have they been turned hostile?
नहीं hostile.
However, they have not been turned hostile.
That is binding on prosecution.
Yes.
Item 33, DA.28.07.2026. of 2026.
Yes, petitioner.
Silent. Yes, there was call from
There's a direction to find a counter.
You have got the case study?
Yes, you don't have a case study. Last year only, you don't have this for case study. So it's stated now.
काउंटर पे नहीं फाइल किया आपके पास केस डायरी है केस डायरी से बेस्ट आपको काउंटर में ही गया ये कैसे काउंटर में फाइल कर रहे हैं नहीं इनके अगेंस्ट में क्या है क्या मिला आपके पास कुछ भी नहीं तो ट्रायल वन मोबाइल आपके नाम से था
बस
आपके नाम से था
वो नहीं आया
किसके नाम से नहीं आया है ये किस तरह का जवाब आपके पास से मोबाइल सीजर है आपके नाम से था कि किसी और का
मेरा ही मोबाइल
अच्छा
मिला है और उसमें दो सिम कार्ड लगा हुआ है
दोनों सिम भी आपके नाम से
जी उसमें जो उसमें इस केस में कोई पर्सन all the three of this person has been granted bail by this member of my law and I am submitting that my case stands on better footing.
कोई एंटीसीडेंट
नहीं इनके आया ये भी 12 में लिखे हैं petitioner has not
कितना क्राइम लिंक
no
crime link no crime link
There is a crime link, that has been given in the paragraph 3 of the case study, and there is a victim also.
no victim has come forward.
Any antecedent?
Antecedent is
Custody since 12/4.
Yes.
12/4 से custody है.
12/4.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner service said the petitioner having no criminal antecedent is in custody since 12/4/2026. Charge sheet has already been submitted. He submits that one mobile and two SIM are alleged to have been recovered from the possession of the petitioner, and the petition has been falsely implicated in this case.
And no victim has come forward to complain any case against.
ये तो बोल रही है victim
That's a victim. That is
the learned counsel for the state has opposed a prayer for bail and has submitted that. And however, she does not dispute the aforesaid submissions made by the counsel for the petitioner. However, she submits that one victim has been identified.
Yes.
कहाँ लिखे हैं? Para number?
Para 49, the statement of the victim cheated through mobile phone recovered for the possession of his petitions mentioned para 49 of the case study.
And certain crime links were also found against the petition. After hearing the learned counsel for the parties and considering the fact that the petitioner has no criminal antecedent and charge sheet has already been submitted, the petition is submitted to the
Okay. Item 34, BA.5191 of 2026.
This is application for grant of liberty. Usually, the fire was insured under section 108 or like 5 of the BN. Now, the charges have been submitted under section 108, 351, subsection 3, and 69 of the BN. From the result of the FIR, we find that
69.
60.
16. It appears from the FIR itself that the deceased who has committed suicide in her blanket was aged 20 years, and the present petitioner is also not the aged 20. Both were having love affairs since long. But the marriage of the victim was performed with another person in the year 2025. This present case has been lodged on 20th February 2026. Against the will of that victim, the marriage was performed. She was
How
having
are
love.
you related to the deceased?
Pardon?
How are you related to the deceased?
How?
You are the ex-boyfriend of the deceased?
Yes. That is happened from the ISF page 50.
Let's see that.
Page 50. The mother has lost their body. मेरी पुत्री so fourth line from the top I am reading. उम्र करीब 20 वर्ष पिता so वर्ष 2025 में ग्राम दुबराज में जिसका शादी वर्ष 2025 में ग्राम दुबराज में दुबराजपुर में हुई, लेकिन मेरी पुत्री का कहना था कि मैं सोहन यादव प्रेजेंट पिटीशनर पिता से प्रेम करती लड़का भी रोज रोज फोन करके मेरी पुत्री के साथ प्रेम प्रसंग किया, शारीरिक संबंध बनाया, शादी का वादा करके बार-बार यौन शोषण करते रहा। जब मेरी पुत्री ने शादी करने को कहा तो उसने इनकार कर दिया और फिर दिनांक 8/2/26 को मेरी पुत्री को फोन कर कहा कि तुमसे शादी करेंगे। मैं मेरा दोस्त ललन यादव पिता मुझे गाड़ी से ले आएगा और मेरी पुत्री को ललन यादव ने सोहन यादव के साथ पहुंचा दिया। रात भर मेरी पुत्री के साथ यौन शोषण किया। जब सुबह हुई तो मेरी पुत्री ने कहा मेरा मांग सिंदूर से भर दो, तो उसने मेरी पुत्री से कहा कि आज नहीं 2-3 दिन बाद शादी करूंगा। फिर जब मेरी पुत्री ने सोहन यादव को फोन किया शादी के लिए, पुत्री शादी से इनकार, उसने मेरी पुत्री को आत्महत्या करने पर मजबूर कर दिया। जिस वक्त मेरी पुत्री आत्महत्या की उससे पहले लगातार दोनों के मोबाइल पर बहुत देर तक बातें हुई और लगभग 17/2/26 शाम 5 बजे के करीब मेरी पुत्री घर के अंदर दुपट्टा से फांसी लगाकर आत्महत्या कर ली। मेरी पुत्री के ससुराल वालों को सोहन यादव तथा सोहन को राखी कुमारी को हम लोग भगा के ले जाएंगे, अपनी साला सोहन यादव से शादी करेंगे। मेरी पुत्री की आत्महत्या में निवेश करने वाले ग्रुप में सभी लोग हैं, लेकिन सरकार ने मंजूरी दे रही है। ये सब मोबाइल में बातें सारी रिकॉर्डिंग मोबाइल में। But the counter has been tried, there is nothing not the mentioned in the counter affidavit that any not the conversation was recorded or anything was not the recorded in not the mobile. Moreover, my lord, the informant is not there. Nobody has seen that not the she had gone to the house of not the petitioner on 8/2/26 and not she has remained there for the whole night. There is nothing in the case that in the counter affidavit also they have not stated this for the
She was already married in 2025.
Yes, but thereafter, but this paragraph said, take of my petition they can be seen. I have stated explicitly that is not the why not the petitioner has refused to marry because during the substitution of the first marriage, the second marriage is already performed. Paragraph 8 and not the 10.
Yes, what do you say?
That it is relevant to mention here, paragraph 8 and 9. It is relevant to mention
Custody
here.
कब से है इसका?
Pardon?
Custody.
Custody not since 10th April 2026, but he has got no criminal incident. There is nothing not the against him that not the except not the FIR law by not the mother. Nothing has come against him. That not the regarding not the second part when not the she had gone to the house of the teacher had established sexual intercourse and thereafter not the.
But as per the allegation, also she went to the house of the teacher.
Yes, she had gone to the house of the teacher. And
Yes,
what
but
it
you
is the
say that.
admitted fact that she was having love.
Sorry? Allegation, you see, she was already married in 2025. She was having some affair with the petitioner. And post-marriage, she went to the house of the petitioner and established physical relationship, and ultimately committed suicide. So petitioner never came to her house to establish any relationship. Affair था तो affair continue हो गया शादी के बाद. That is why she went. मायके में रही. Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petition submits that, as per the FIR itself, the deceased wanted to marry the petitioner. However, she was married to somebody else in the year 2025. Subsequently, she wanted to marry the petitioner. Subsequently, also she wanted to marry the petitioner. And in the FIR, it has been released that the deceased went to the house of the petitioner, where she established physical relationship with the petitioner and insisted that the petitioner should marry her. The learned counsel submits that thereafter the deceased committed suicide. Charge sheet has been submitted under section 108/351 within bracket 3 and 69 of the US. And the petitioner is in custody since 10/4/2026. The learned counsel submits that there was no question of any marriage with a lady who was already married. And the deceased used to live in the house of her parents. It appears that there was love affair between the petitioner and the victim, but she got married to somebody else and ultimately she committed suicide. The learned counsel for the state has opposed the prayer for bail and has submitted that there is allegation that the petitioner established physical relationship with the victim, with the deceased, even after marriage. And therefore the petitioner may not be enlarged. After hearing the learned counsel for the parties and considering the sequence of events as mentioned in the FIR itself, it appears that the deceased was already married in the year 2025, but she throughout wanted to marry the petitioner. And thereafter, she went to the house of the petitioner and also established physical relationship with him and ultimately committed suicide. In view of the aforesaid facts and circumstances, since the petitioner was already married, there was no question of, since the deceased was already married, there was no question of petitioner marrying a married lady. The charge sheet having already been submitted, the petitioner is eligible to be enlarged on bail.
Item 35, BA 5204 of 2026.
This is the case registered under section 3, 64.
Yes.
64 of BNS. And in this matter, after investigation, charge sheet has been submitted in section 64 and 51 of BNS.
There is a statement of the victim under section 183.
Lordship, there you need to call for that statement. And notice was also issued to victim.
Below our notice, I am appearing on behalf of the informed.
There is a statement of the victim under section 1.
Below informant herself present in the court, below she has come today.
Are you opposing?
No, my lord, she wished to say something, but on instruction, she had stated that there was some confusion, that is why the case had been.
She has been examined before the court.
Charge has been submitted, and lordship has been pleased to direct the respondent state that to I together any photograph or videograph has been recovered during investigation, and the specific counter has been filed that no photograph or videograph is available. Page 9 of complaint में kindly refer to.
इनका स्टेटमेंट कहाँ है 183 का? मंगाए थे ना हम लोग?
Informant has also come
शादी हो गया सर?
शादी लड़की का हो गया है, वो तो आया हुआ है काउंटर में पेज 8 में आया हुआ
उनका स्टेटमेंट नहीं है, उनका स्टेटमेंट 183 का बेसिस का स्टेटमेंट नहीं है. It's not there. FIR पढ़ी तो
पेज 18 is the FIR. श्रीमान से कहना है कि मैं स्वयं सो हजारीबाग का रहने वाला हूँ. मैं का उसका नाम मोबाइल दुकान में मेरे मोबाइल दुकान में साल 2020 से काम करना शुरू की. काम करने 100 महीने बीतने के बाद जिसका नाम है उसी बीच हमारे साथ शारीरिक संबंध बार जबरन बनाया और संबंध बनाने के बीच फोटो खींच लिया और उस फोटो से मुझे लगातार 5 साल तक शोषण किया और मुझे धमकी देता था कि किसी को भी बताओगी तो तुम्हारे साथ सारे परिवार को जान से मार देंगे.
चार्जशीट किस सेक्शन में?
IR 64 और ये
ऑक्सो भी लगा है
308 IPC एक्सटॉर्शन ऑफ मनी के लिए भी IR हुआ. चार्जशीट सबमिट हुआ 351 criminal intimidation and 64 of PNS.
काउंटर में क्या आया?
काउंटर में आया
for the counter for the state. Yes, what are you stating in the counter? कोई वीडियो सीज हुआ है? नहीं हुआ ना?
यानी वो तो खास इस स्टेटमेंट में पेज 9 पहले देखा जाए तो दिया गया स्टेटमेंट है. वार्निश ऑफ पीड़िता से संपर्क कर उसका फोटो वायरल करने के संबंध में पूछताछ किया गया तो वादनी के द्वारा इस संबंध में कोई ठोस साक्ष्य प्रस्तुत नहीं किया गया है. ये पेज 9.
The learned counsel secreting on behalf of the parties. The learned counsel for the petitioner submits that as per the FIR, the petitioner and the victim, the first incident had taken place 5 years back, and in the year 2020, and the petitioner and the victim did not lodge any case on the ground that the petitioner had certain photographs slash video, certain obscene photographs slash video. He submits that as per the counter affidavit, no video slash photograph have been seized. The learned counsel appearing on behalf of the state, though has opposed the prayer for bail, but the aforesaid submissions are not in dispute. So far as the learned counsel appearing on behalf of the informant is concerned, he submits on instruction that the case was lodged under some confusion. Correct? and the informant has no objection if the petitioner is enlarged on bail. After hearing the learned counsel for the parties and considering the fact that the petitioner, as per the FIR itself, some video, etc., was prepared, and the relationship, and on the pretext of such obscene video, etc., the petitioner and the victim, the petitioner made physical relationship with the victim, but no video or photograph has been recovered. The charge sheet has already been submitted. Accordingly, the petitioner is directed to be enlarged.
कंडीशन ऑफ बेल में कल एक बेल पर उसका डेट ऑर्डर आ जाएगा। कंडीशन ऑफ बेल में ये था कि एक डेट में भी अगर अपीयर नहीं करेगा तो इसमें आएगा या नहीं आएगा कंडीशन ऑफ
ऐसा हर एक केस में ही करते हैं, किसी भी केस में करते हैं। वो 2014 से गायब है, इसीलिए ऐसा कंडीशन है।
वो तो होता है, लेकिन मेरा सबमिशन ये है कि एक रीजनेबल ग्राउंड तो
नहीं
एक डेट के लिए तो होना ही चाहिए ना।
ऐसा बात नहीं, एक एडवोकेट तो अपीयर करेंगे ना।
एडवोकेट अपीयर करने के लिए नहीं ना वो ऑर्डर
नहीं,
है।
वो सब ऑर्डर रहता है।
नहीं, जो अभी कल ऑर्डर हुआ आज ही हम देखे, उसमें ये कंडीशन था कि एक डेट भी अगर मिसयूज हुआ तो उसका बेल बॉन्ड कैंसिल हो जाएगा।
हाँ, तो ये आपकी कंसेंट से ही लिखा है, petitioner के कंसेंट से लिखा है। चलिए, ये तो हम बेल नहीं दे रहे थे।
1936
2014 का केस में हम क्यों बेल देंगे 2026 में? आराम से रहेगा, एक आध साल जेल में।
मेरे केस में ऐसा नहीं हुआ था, मेरा केस तो अभी 2026 का ही था, इसके बावजूद भी वो कंडीशन आया, इसलिए मेरा सब
हो सकता है कोई कारण रहा होगा ऐसा हम ऑर्डर करते हैं।
सांप वाले में सांप का जो कल केस किए थे कि सांप निकल गया घर में, उसमें ये कंडीशन आया मैडम।
आपका इतना एक बार ऑर्डर साइन करने के बाद हम
ये हम नहीं कर रहे हैं, हम कह रहे हैं वो कंडीशन इस केस में ना आए, इसलिए
ऐसा नहीं होता है, इस तरह से नहीं होता है। जिसमें स्पेसिफिक कंडीशन देना होता है उसमें स्पेसिफिक ऑर्डर दीजिए। You are filing it?
Yes.
File it. Where is the petitioner? This one.
On 22nd of June, case diary has been called off, and victim is a major and married woman and had a children also in this case. And charge sheet has been saying in lordship.
Where is the statement of the victim under section 183? We have called for the statement.
Yes, and लॉर्डशिप पीआर बॉन्ड भी हुआ था जिसमें विक्टिम पैसा लेके कॉम्प्रोमाइज की थी, एंड केस डायरी में भी आया है लॉर्डशिप, दोनों गवाह भी बोले हैं, सपोर्ट किए पिटीशन। एंड पेज नंबर 17 ऑफ केस डायरी।
You read that, right?
पेज नंबर 17। निवेदन पूर्वक कहना है कि मैं ज्योति कुमारी हूँ, मुनीश्वर पिता सचिन सच, थाना सचिन सच, हजारीबाग की रहने वाली हूँ। यह कि वर्ष 2024 दिसंबर माह में इंस्टाग्राम सोशल मीडिया पर मेरे घर के बगल के किराए पर चला रहे इंडियन गैस एजेंसी के शिवम कुमार सिंह, पिता सचिन सच, ग्राम सचिन सच, जिला चतरा, मेरे मोबाइल तथा व्हाट्सएप पर मैसेज तथा हमसे बोलने लगा कि मैं तुमसे शादी करना चाहती हूँ। तो मैं बोली कि तुम जानते हो कि मैं शादी हो गई है। तो फिर भैया मुझे कहने लगा कि ठीक है, मैं फिर भी तुमसे शादी करूंगा। जिसके बाद फरवरी माह 2025 दिनांक 16/2/2025 के करीब 11:30
इस तरह का एलिगेशन है, मैरिड लेडी को जबरदस्ती शादी करना।
लॉर्डशिप ऐसा कोई एलिगेशन या कॉम्प्रोमाइज भी हुआ था लॉर्डशिप। ऑलरेडी पीआर बॉन्ड में जो फाइल है लॉर्डशिप, पेज नंबर
कॉम्प्रोमाइज में क्या हुआ?
एनेक्शन टू पेज नंबर 20।
व्हाट हैपेंड इन कॉम्प्रोमाइज?
लॉर्डशिप की पैसा लिखी है 75,000 लेके बोली कि अब हम कॉल मैसेज कुछ नहीं करेंगे, ना ही लड़का करेगा ना ही लड़की, विक्टिम भी नहीं करेगी, पिटिशनर भी नहीं करेगा।
कहाँ है कॉम्प्रोमाइज?
लॉर्डशिप पेज नंबर 20 पीआर बॉन्ड। लॉर्डशिप उसमें लिखा हुआ है दोनों पक्षों के द्वारा ये वादा किया गया है कि हम लोग के मोबाइल में फोटो वीडियो जो भी है वो डिलीट हो जाएगा।
कंपाउंडेबल है क्या ऑफेंस? कंपाउंडेबल ऑफेंस है क्या?
64
It is compoundable offense.
Yes, it's fine.
Yes.
And
काउंटर नहीं मिला है लॉर्डशिप,
किसको नहीं?
रिसीव नहीं हुआ काउंटर।
For अंशु कुमारी कौन? आप ही तो कोई रिसीव किया। How do you say we are not received it? हम बताएं।
उसने इसमें जो बताया कि पंचायती हुआ, पंचायती के बाद भी ये बात नहीं माना और जहाँ गई वहाँ पे बंद लिया, इम्प्लाई कर दिया और उनके साथ कैलकुलेशन हुआ, बाद में रिड्यूस कर दिया है। ये भी हुआ पंचायती के बाद हुआ कि डायरेक्ट सबमिट कर दिया।
16 फरवरी 2025 सेकंड इंसिडेंस होता है।
Madam, you just tell me one thing. Is it a compoundable offence? 3 लाख रुपए लेके कॉम्प्रोमाइज कर दिया, इसका क्या मतलब है? You are influencing the witnesses.
Then what? First incidence पे लॉर्डशिप 16 फरवरी 2025 को है, सेकंड इंसिडेंस 14/8/2025 को हुआ है लॉर्डशिप, उसके बाद पीआर बॉन्ड हुआ लॉर्डशिप 7/9/2025 को। एफआईआर भी वो लॉन्च
केस का क्या स्टेज?
15/10
स्टेज का
चार्जशीट हो गया लॉर्डशिप, इन्वेस्टिगेशन कंप्लीट।
What the learning council is appealing on behalf of the your father? क्या बोलना है? कॉम्प्रोमाइज करते हैं 3 लाख रुपए।
because there is 16 para 16 में भी आया हुआ है, फिर वो फर्दर अगस्त में वैसे ही हरकत किया, फिर मेरा फैमिली को डिस्ट्रॉय कर दिया।
अगस्त के बाद लॉर्डशिप
For the learning council is appealing on behalf of the parties. The learning council for the petitioner submits that the petitioner has been falsely implicated in this case, in as much as the victim was already married, and in spite of that, it is alleged that the petitioner wanted to forcibly marry the victim and entered into his house and committed rape upon him. Forcibly entered into her house and put vermilion on her head and also Mangalsutra, and also established physical relationship forcibly. The learned council has submitted that there was settlement between the parties and PR bond was also executed. The learned council for the state, and now chargeshit has already been submitted. The learned council for the state has opposed a prayer for bail. State as well as the victim have opposed a prayer for bail and has submitted that the petitioner has been repeatedly troubling the victim, who is a married lady, and there are direct and specific allegations against the petitioner. Chargeshit has been submitted on 21/5/26 under section 81/69 of BNS. After hearing the learned counsel for the parties and considering the direct and specific allegation made against the petitioner, this court is not inclined to enlarge the petition on bail henceforth. ये वकालतनामा टिप्पणी मांगे।
Item 37 DA.28.07.2026 of 2026.
In this case, petitioner paid for regular bail. This is offense under section 498A and along with other sections are there. 109 also, 85 and 109 of BNS. In this case, only against the petitioner the 20 criminal antecedent. Otherwise, it is a matrimonial dispute
between the husband and wife, and therefore this case has been lost. And that 20 cases, Lordship, almost 10 cases he has been acquitted, and 2 cases, Lordship, 1 case is already final form has been submitted in favor of the petitioner, and 1 case, Lordship, he is not an accused. If your Lordship allow me to read the first information report. I have filed a supplementary affidavit also. Charge sheet is already.
Victim has turned hostile.
Bigger person.
Victim has turned hostile.
Victim ने इसको लड़की जब
मैं इस केस की पीड़िता हूँ.
that is another case, Lordship. Annexed 2, my Lordship, may be. Annexed 2.
अच्छा लंच के बाद सुनते हैं. 2-3 केस बाकी है, लंच के बाद सुनते हैं.
Actually, she has her daughter. She has filed a case through her daughter. Annexed 2 में वही थी.
I'll see. 2-3 केस बाकी हैं. 3 केस बाकी. लंच के बाद सुनिए. हम लोग का भी तो कोई ह्यूमन राइट्स है.